Royal Commission into the Robodebt scheme is now in session. Please be seated.
Yes, some appearances, I think, please.
Yes, thank you, Commissioner. Today I appear with Mr Scott of King's Counsel and Ms Berry of Counsel. Commissioner, Mr Scott was appointed King's Counsel after the conclusion of the first public hearing.
Yes, I'll remember that. For the Commonwealth?
Commissioner, today I appear with Mr Glover of Counsel and Ms Kelly of Counsel.
Thank you. Mr Andreatidis?
Andrew Tithis, ANDREATIDIS. I appear with Ms K.E. Slack of Counsel, and we appear on behalf of Mr McNamara.
Thank you. Yes, Mr Gregory?
Yes, thank you, Commissioner. I intend to provide a short opening address in respect of this second public hearing, but at the outset I can say that it is shorter than it might otherwise have been because of the need to accommodate limitations on the availability of witnesses today. 2 weeks ago, the Commission updated the Robodebt Royal Commission website with an overview of the topics which are proposed to be covered during this public hearing, which starts today and will conclude on Friday, 16 December 2022. The second public hearing will add to the evidence given by witnesses and tendered in documentary form at the first public hearing. That hearing brought a significant body of facts into the public domain which were not previously known to the hundreds of thousands of Australians who were adversely affected by the Robodebt scheme. Despite the volume of documents and the evidence of the witnesses called in that hearing, some gaps remain. For this reason, the second public hearing will continue the inquiry into the establishment, design and implementation of the Robodebt scheme, together with the impacts of the scheme on individuals. It will also commence the inquiry into topics after the scheme was implemented. As set out on the Commission's website, the focus for this hearing will be upon the following matters: the impacts of the scheme on individuals, data matching and compliance with privacy laws and data matching guidelines, the role played by the budget process in establishing the scheme, the measures necessary for it to continue, and the involvement of portfolio ministers and senior executive service officers in that process, the extent of planning and testing undertaken during the pilot stage, the investigation undertaken by the Commonwealth Ombudsman, the experience of representative bodies and the government's response to identified shortcomings in the scheme, and the means of debt recovery, including the use of debt collectors and commissions on amounts recovered. The proposed witness list was published on the Commission's website last week. Some of those who are listed to attend gave evidence in the first public hearing. The decision to recall those witnesses reflects either the need to clarify some aspects of their evidence in light of further documents which have been produced, or to complete their evidence. On the point of documentary production, as at Friday, approximately 442,000 documents were produced to the Commission so far. The teams supporting the work of the Commission face an enormous and ongoing task to review those documents for relevance and substantive content. That task will of course not be completed during this hearing block, and the proposed witness list for this hearing block does not include a number of persons who are expected to be in a position to assist the Commission with the factual questions asked by the letters patent. For these reasons, I confirm that 2 further public hearings are scheduled in 2023. The dates of those hearings are now listed on the Commission's website also. A number of witnesses have provided statements or soon will provide statements and produce documents, but will not be called in the time available during the next 2 weeks. Those persons are likely to be called to give evidence at the hearing commencing late January and of course should plan accordingly. The need for further hearings arises from the time consumed in the systematic collection and analysis of evidence required to provide answers to the terms of reference as comprehensively as possible prior to the provision of the Commissioner's report to the Governor-General on 18 April 2023. I expect that the documentary and oral evidence to be given during this hearing on the topics I outlined earlier will, together with the evidence provided in the first hearing, achieve the body of evidence necessary to resolve a number of the questions asked in the letters patent. First, I expect the evidence will complete the range of evidence to be called on the questions which surround the design and implementation of the scheme, including from the perspective of social security policy. These topics include the subcategory of the process of data matching between the Department of Human Services and the Australian Taxation Office. This topic was introduced at a relatively high level in the first public hearing from the perspective of both the proper officers of the ATO and DHS. That process involves the matching of identities and then the matching and provision of financial information on a large scale. The evidence before the Commission currently in respect of the legal basis on which that information was matched and exchanged is very different. The evidence of the proper officer of the ATO was that the process was undertaken under the Data Matching Program, Assistance and Tax Act 1990, until the scheme commenced in July 2015. In contrast, the evidence of the proper officer of DHS was that it was conducted under the 2004 Data Matching Guideline prior to the commencement of the scheme. Further evidence will be given from persons employed by DHS and ATO, which may assist resolving that inconsistency on the authority to undertake data matching. Their evidence will also include more technical aspects of the data matching process and the interactions between the ATO and DHS to enable the scheme to be implemented in the time available prior to 1 July 2015. The evidence will also address the context of privacy laws and data matching guidelines issued by the Office of the Australian Information Commissioner. Secondly, I anticipate the evidence will answer in large part the intended outcomes of the scheme as it was forecast by the Departments of Social Security and Human Services in the process of developing the proposal to the point where it became the original budget measure which first introduced the stages of the scheme. This aspect of the evidence will include costings of the budget measure, both savings and outlays, over the projected 4-year period from 1 July 2015. Thirdly, I anticipate the evidence will provide a partial, that is, the start of the answer, to the actual outcomes of the scheme, particularly in this hearing categorised by the number of alleged debts which were raised, the projected savings of those debts, the money actually recouped under the scheme for the period from April 2016 to approximately December 2018. What might be expected is that the actual outcomes of the scheme in those categories fell well short of the targets projected in early 2015. Fourthly, I anticipate the evidence to begin the inquiry into the response of the government ministers and the departments to representations made by peak bodies about shortcomings in various facets of the scheme. In this hearing, representatives of the Australian Council of Social Service, ACOS, and the CPSU will give evidence of their interaction with the government in late 2016 and early 2017. Both of these peak bodies represented very different groups of persons who were adversely affected by the scheme. ACOS represented those who received debt notices, and the CPSU represented those who worked within Centrelink and were tasked with the day-to-day administration of the scheme. Both groups felt the impact of the scheme in different ways, and the bodies which represented them are in a position to give evidence about their representations and the government response. Fifthly, I anticipate the evidence will also include the impact of the scheme on those who were affected by it, and that will continue to be a focus of this hearing. Material was tendered during the first hearing, which was produced by the department, together with many thousands of other documents in response to a broad notice. The particular material, which comprises emails, letters and notes, related to the efforts made by a particular Centrelink employee to draw Ms Campbell's attention to the obvious flaws in the scheme and the difficulties faced by Centrelink staff in administering it. That evidence is valuable to the work of the Commission because it provides evidence of actual knowledge of persons in positions of seniority within the department and an insight into the mindset of the department during the operation of the scheme. Commissioner, those assisting you understand that employees of Centrelink would have felt restricted in their ability to speak publicly about the effect of the scheme upon them personally and in respect of their assessment of its shortcomings during the life of the scheme. This Commission provides the opportunity for those accounts to be given, both by witnesses and through submissions. The particular case to which I am referring, through material written by an employee to the Secretary of the Department at a critical time of the scheme, is one body of such evidence. And ideally, that employee would be able to give evidence of her experience surrounding the information that she sent to the Secretary. That material was not reached in the examination of Ms Campbell during the first hearing due to time limitations, but it will be reached during this hearing. It contains a direct and detailed explanation of the flaws in the scheme and the department's response. Both of those aspects of the material provide insight into the questions of why the scheme continued despite both internal and external criticism. Two persons will give evidence who fall into the category of those who might be represented by ACOS, one later today and one Friday next week. Their evidence also provides a personal account of the human cost of the scheme, which will supplement the evidence of ACOS, which relates to representations at a ministerial level in respect of social security policy and legal issues. And that occurred at a very early stage. On the topic of submissions, the Commission has received many hundreds of submissions from a wide range of persons. Again, those submissions have been made by persons who wish to remain anonymous and those who are content for their identity to be made public. They provide a substantial body of evidence which will assist the Commission to make findings which will be contained in the final report. And the content covers a wide range of topics and perspectives, from personal impact or observations to legal analysis and policy considerations. All submissions are read by the submissions team, categorised, read more broadly by those assisting the Commission, and personal follow-up, or at least some attempts to do so, occurs in a number of instances. Where a person provides their contact details on a submission, it is possible for the Commission to issue a notice to that person should the person wish to give evidence. And I reiterate what I said at the initial hearing, that witnesses who give evidence at the Commission are protected by the provisions of the Royal Commissions Act 1902, which creates an offence for anyone to cause or inflict any damage, loss or disadvantage on account of them appearing or giving evidence or producing documents. Sixthly, I anticipate the evidence will include two persons who were ministers of the relevant departments of social services and human services at the time the scheme became part of the federal budget in May 2015. The Honourable Scott Morrison and Senator the Honourable Maurice Payne. The evidence that they are likely to give, like much of the evidence given in the first public hearing, is anticipated to be information which was not in the public domain prior to the commencement of this commission. The evidence of the former Ministers for Human Services, the former Minister for Human Services, Senator Payne, is likely to commence Tuesday next week, and the evidence of the former Minister for Social Services, Mr Morrison, is likely to commence Wednesday next week. Their evidence should complete the body of evidence in respect of budget matters, policy and legal considerations in 2015. Successive ministers of DSS and DHS are likely to be called in subsequent public hearings in respect of their knowledge of and involvement in the scheme. They are persons within the description of those in positions of seniority to which the letters patent draw attention. I turn to the question of public interest immunity rulings. On 23 November, Commissioner, you made a ruling in respect of 4 documents which consist of 2 emails and their respective attachments. The ruling was published on the Commission's website on 25 November 2022. As outlined in the ruling, the attachments are iterations of the new policy proposal, which became the Strengthening the Integrity of Welfare Payments budget measure. Those measures include the initiation of compliance measures now known as the Robodebt scheme. Your order, Commissioner, was that the 4 documents be produced with some redactions, and the reasons set out that the draft policy proposals and the emails which forward them are relevant to a critical question to the Commission's inquiry, whether any need for legislative authority for a component integral to the Robodebt measure, the use of PAYG data obtained from the Australian Taxation Office to determine benefit entitlement, was communicated to government, and if not, how that came about and at whose behest. Those documents will be tendered in the course of this hearing, and questions will be asked of witnesses who have or may be expected to have knowledge of them. On Friday, 2 December 2022, Commissioner, you made a further ruling in respect of additional documents produced in respect of the anticipated evidence of former Ministers Payne and Morrison. The ruling remains provisional insofar as it provides an opportunity for those representing Mr Morrison to make submissions in respect of the ruling by close of business today, and a further opportunity for the Commonwealth to respond should that occur. I don't propose to tender any documents given its provisional status, but I expect to be in a position to do so perhaps by tomorrow afternoon or Wednesday morning, prior to the resumption of the evidence of Ms Campbell. Those documents are directly relevant to the resumption of her evidence, who I consider to be in a position to give evidence about her knowledge of the content of them. In terms of some housekeeping matters finally, Mr Scott will take the evidence of Mr McNamara due to commence very shortly, and I will return to take the evidence of Ms Klieve at about 4 p.m. this afternoon or at a convenient time in Mr McNamara's evidence. May it please the Commission.
Thanks, Mr Gregory. Mr Scott.
Commissioner, at the outset, before Mr McNamara is called, I propose to hand up a list of the exhibits that will be tendered in the course of the evidence today. Representatives for Mr McNamara and the Commonwealth have copies, and I propose to tender some but not all of the exhibits on that list, in particular those down to and including Exhibit 1689 at the outset now, if it pleases the Commission.
All right. The documents as listed in the schedule, 1296 to 1689, will be admitted as exhibits bearing the numbers they bear in the schedule.
Thank you, Commissioner.
Commissioner, could I just have it recorded or have it noted for the record that the documents up to or prior to the statement of Mr McNamara are a bundle described as the Ombudsman bundle for those assisting the Ombudsman, who I understand will be assisting the Commission in future hearings. That material will be in evidence from today.
Thank you, Ms Hogendoren. Yes, Mr Scott.
Thank you, Commissioner. Just some further brief housekeeping matters before Mr McNamara is called. In particular, there's some matters that I need to put on the record in relation to Mr McNamara's evidence, and I understand his counsel have some matters, or a matter to raise as well. In terms of what I have to raise, his evidence is not completed by the time the next witness is required to be called. It's envisaged that he will be recalled in hearing block 3, and given the scope of his evidence, that is a possibility. The second matter that I have to raise is that late last week we received, solicitors assisting I should say, received notice from those acting for the Commonwealth that the Commonwealth has some public interest immunity claims over some parts of Mr McNamara's statement and indicated some redactions consistent with those claims. Given the timing, I'm content.
Sorry. When you say late last week, what do you mean?
Just need to check that, Commissioner. I'd have to get those details. I'm getting those details brought up. I think it was Thursday or Friday, but I'll need to confirm that. But what I propose to do in terms of dealing with those redactions is to proceed with the statement redacted at present, and it may be necessary at a later time to seek a ruling in relation to those claims of public interest immunity.
Well, is there a copy of the redacted statement for me so I can understand what it is that is the subject of the proposed rulings?
It should be in the bundle, Commissioner.
I'm looking in the bundle, and understatement of Jason McNamara is...
Commissioner, as I understand it, Exhibit 1610 is a redacted version of the statement. There are,
Find it.
if it is the document as I understand and am instructed it is, yes it is, the relevant paragraphs have been redacted.
Well, just tell me the first one, Ms Hogendora, and I found a statement.
It's 91, paragraph 91 is the one
91.
on page 16. And could I indicate, I don't wish to say much about it, but I anticipate that some, if not all of these, will fall away depending on the outcome of your ruling that is currently provisional.
All right, I've got it now. Thank you.
Sorry, I'm just excuse me one moment, please, Commissioner. Commissioner, I misled you unintentionally. I understand and am instructed that the redactions are consistent with the rulings you have made to date. Whether or not they're affected by this, I'm not in a position to say something about that, but I understand it may not be.
Okay, thank you. We can proceed.
Thank you. And just for the record, I understand the redactions were received from the Commonwealth on Friday, I'm instructed.
I'm sorry, I didn't hear that word.
I'm instructed by solicitors assisting that the redactions were received by them from the Commonwealth on Friday.
Thank you.
Thank you, Commissioner. So I understand Mr McNamara's counsel has a matter to raise.
Yes, Mr Andrew Tidis.
Commissioner, Mr McNamara has a medical condition that affects his back, and consequently he needs to stand whilst giving his evidence. I'm also instructed that he has a medical condition under treatment from a specialist that requires the taking of certain medication, and from time to time Mr McNamara may need to request a short break. Could I thank you, Commissioner, counsel and solicitors assisting, and the Commission staff for accommodating Mr McNamara. Thank you very much.
Yes, so he'll just stand and let us know when he needs a break.
Yes.
Thanks. Yes.
Commissioner, I call Mr McNamara.
Mr McNamara, will you take an oath or an affirmation?
I'll take an affirmation. Thanks, Commissioner.
Your response is I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr McNamara, could you please tell the Commission?
McNamara?
You were issued a notice to give a statement and produce documents dated the 6th of November 2022 by the Commission.
That sounds right.
You initially produced a statement and a supplementary statement in response to that notice.
I did.
You've since produced a consolidated statement that consolidates the contents of your initial and supplementary statement.
I did. Yes, that's right.
And the consolidated statement is dated the 1st of December 2022.
That's correct.
And are the contents of your consolidated statement true and correct to the best of your knowledge and belief?
Yes.
Thank you. That can be taken down. Now, it's the case, Mr McNamara, that presently you are retired.
No, I'm on long-term leave from the agency.
When you say the agency,
The Services Australia.
you've had a 30-year...
Correct.
You joined the Department of Human Services, what is now Services Australia, on the 26th of April 2016.
That's correct.
Between 26 April 2017 to 2 March, between 26 April 2016 to 2 March 2017, you were the General Manager of Audit.
That's correct.
And from March 2017 to July 2017 and April 2018 to May 2020, you were the General Manager, Integrity Modernisation Division.
That's correct. The only qualification to that was in the period from January 17 to March 17, I had a unofficial role in what was the Integrity and Information Group.
Yes.
Which I talk about in my statement.
Yes, we'll come to that.
Yep.
And there was a period from July 2017 to April 2018 that you were the Acting Deputy Secretary, Integrity and Information Group within the agency.
That's correct.
Thank you. Can you please have up on the screen doc ID CTH 3502 0001.1462, which is Exhibit 1686. Now, Mr McNamara, you should be able to see on that screen what purports to be an organisational chart.
Yep.
And you can see if we call out the wording on the top left-hand corner, commencing Senior Executive Structure.
That's right. Yep.
See that? Senior Executive Structure, Department of Human Services.
Yes.
And then in the blue section towards the top right, call out the words commencing this chart reflects.
Yep.
All right. So that depicts, this chart depicts the department's structure and position occupancy effective 6 March 2017.
Yep.
See that? And then towards the top left, in blue, are the words Catherine Campbell, Secretary.
Yep.
See that?
Yep.
Okay. Now, I'm just interested in the column headed in yellow, Integrity and Information.
Yep.
See that?
Yeah.
And the deputy, that depicts that at that time, the Deputy Secretary for that part of the department was Melissa Golightly.
Yeah.
And then if we go down to the bottom of that section, you can see the words integrity Process Modernisation, Jason McNamara,
Yep.
General Manager.
Yeah.
Okay, and can we take it from that in that role as Integrity Process Modernisation, that your report, the person you reported to was Melissa Golightly?
Yeah, that's true. Yep.
Okay, all right. And if we just go two columns across, the next section in red, headed Enabling Services, Jonathan Hudson, Deputy Secretary.
Yep.
And was Enabling Services a different part of the department at that time?
Yeah, that was a different group.
Okay, and the Deputy Secretary for that part of the department was Jonathan Hudson.
Yes, that's true.
And am I right, you didn't report to Jonathan Hudson?
Not once I moved, but when I was General Manager of Audit, yes, I reported to Jonathan.
I see. So were you part of Enabling Services prior to moving to Integrity and Information?
Yeah, that's my position there, vacant. The audit vacant position, that was the position I just left.
I see. Okay. So am I right that from the start of 2017 until when you moved to the role in Integrity and Information, you reported to Mr. Hudson?
So from the start of, yeah, from the, sorry, can you repeat the question?
From the start of 2017 until when you moved?
No, yeah, from the start of, so at the very beginning of 2017, I would have been working for Jonathan. And then at some stage during January 2017, I started working for Melissa.
Okay. Even though you hadn't formally changed?
No, it wasn't a formal announcement of a new division or a new role. It was just a, can you please help out?
Okay. All right. That document can be taken down. And can we then bring up CTH dot 3502 dot 0001 dot 2883, exhibit 1687. All right, you can see that also purports to be an organisational structure for the department.
Yep.
We just call out the top right-hand section. The words on the top right-hand section, thank you. And you can see this reflects the position as at 1 May 2017.
Yep.
Okay. And if we go again to the yellow section headed Integrity and Information.
Yep.
Again, Melissa Golightly is the Deputy Secretary at that time.
Yes, that's right.
And am I right that at that time you were GM for Integrity Modernisation?
Yeah, that's right.
And reported to Ms Golightly at that time?
That's correct. Yep.
All right, that document can be taken down. Now, you just mentioned that for that period, that early period in 2017, even though you were in the role in audit, reporting to Mr Hudson, you were asked to help out Ms Golightly's part of the department.
That's correct.
Okay. And what was the sequence of events that led to that occurring?
I don't remember who asked me to move, whether it was Catherine Campbell or Melissa Golightly or Jonathan Hudson, I can't remember, but someone said, can you come and help around about that time. So it would have been one of those three who would have asked me to ask. You get invited to move and help. I don't think you get a choice in my positions, but yeah, about that time.
And what was, appreciate you can't remember who it was who asked you, but can you recall the nature of the discussion around why it was you were needed to help?
I think it was mainly because the income compliance program was in the media, so there was a significant media issue. And so my background, having worked in central agencies, meant that I was it wasn't unusual for me to deal with small p political issues. So that was my skill set. I had a degree of political awareness to bring into that phase, And I also had just come out of PM&C where I've been running the behavioural science team, the beta team. So I had a expertise in sort of customer-centric behavioural science.
And so when you came into Melissa's section in early 2017, what role did you perform?
So day to day, I was probably, I was dealing with media requests. So there was often requests to our media unit about an aspect of the income compliance program, and I'd be helping in terms of shaping the responses that would go back to whichever media outlet. At that time, initially in January 2, I would have been getting across the program for the purposes of briefing the minister. So, yeah, again, I'd had an extensive career and experience in dealing with ministers and being able to translate technical language and technical issues to ministers. So I was getting on top of things and preparing briefing material for the minister in his office. They were probably the major things before I went on to then transformation of the program, which was probably a bit more later into January, I think.
All right, so when you say briefings to the minister, were these written or oral briefings?
It could be both. Generally, question time briefs or just briefs. The minister would ask a question or his office would ask a question. How does this work? What did we do? What do we normally do, etc. And I'd be there to help. I would have said what I was doing was simplifying the language. So the compliance officers and the people in compliance division knew the reference material, but they tended to write it in a very technical way and a very long way. So I'd sort of shorten it up and make it accessible to the minister in his office.
When we're talking about the minister, which minister are we talking about?
Talking about Minister Tudge.
The Minister for Human Services?
Human Services.
Okay. How frequently would you say you were in his office at this time in early January 2017?
I don't remember how frequently I was in his office. No. Looking back over that 6-month period from January to July, I think I might have met with him half a dozen to a dozen times, something in that order. And his office, maybe a bit more, but often on the phone to his office, a lot. Yeah.
So a lot during that early period?
Yeah, a lot. I became the person they'd ask questions to, and I'd be sort of if they didn't go to Melissa or to Catherine Campbell, they would come to me and say, can you find us a data or can you find us an answer to this question? And I would go into the rest of the agency and find them the answer. And
would this be generally in the context of media inquiries that the Minister's office had to deal with?
Yeah, generally it was media. Or sometimes, it could be the opposition asking some sort of question or something like that.
Did you have many dealings with the Secretary, Ms Campbell, during this time?
Yeah. I mean, every meeting I had with the minister that I can recall, Catherine Campbell was always there. Not so much in terms of one-on-one calls. I mean, occasionally Catherine would call me, but that was pretty rare. She would normally go via Melissa. So Melissa Golightly would ring me and say, Catherine wants something as well.
Did you receive any instruction from Ms Campbell as to talking points for the purpose of responding to media inquiries?
Well, it would have been normal. Catherine was a detailed person. It would have been normal for Catherine to clear anything and involve herself in language and that. So, yeah, she would have provided feedback.
Okay. What about Melissa Golightly?
Yeah, Melissa was another person who liked to redraft things. So, yes, she would. I mean, we had it was very hierarchical. So it wasn't a case of me. I mean, maybe I might go straight back to the minister's office on a couple of points, if it was detailed, but like a typical media request would be I'd prepare something and it'd go up the hierarchy to our media people. It'd go to various people to have input into, depending on what was being asked.
What about Anna Mussolino?
Depending on what was being asked, she could be involved in the clearance process, or her staff, yeah. But it just depended on what was being talked about and what was being asked.
What sort of things would involve Miss Mussolino in those discussions?
If anyone had raised any legal issues, she was the person you would consult with.
Okay. And what about Mr. Hudson?
Not really. No, I probably wouldn't have gone to Jonathan much in this new role. No, I wouldn't have dealt with Jonathan much. Although Jonathan was often the person who Catherine would also go to, Catherine Campbell would also go to essentially give direction and instruction. So if Catherine wanted something done, she would go to Melissa, but she might also go to Jonathan. And so Jonathan might come to me and say, Catherine wants X or Y done.
Okay. What about Craig Storen?
So Craig Storen, I think, followed a similar path to me in the sense of he came in to help about the same time and help out. Although he might have already been there doing a different job and then sort of got drawn more and more into the income compliance program. I think Craig might have been doing the information general manager role at that time. And he got drawn more into it. And then at some stage in that first part of 2017, they moved Craig to the general manager of compliance division.
Okay. Now, is it the case that at some stage in this period in early 2017, you became involved in assisting with the department's response to a Senate inquiry into the Robodebt scheme?
Yes, I did.
And what was your role in relation to that?
Coordinating, helping out with briefing is how what topics we were going to brief on, the structure of briefing. That was sort of what I was helping prepare witnesses by drawing together material. And again, that translation type piece, there's plenty of material around it. It's about putting it into a form that others would understand.
All right. So you mean assisting witnesses for the Senate inquiry?
Yeah. So Melissa Golightly was a type of person who used to like to read at those sort of things. She wasn't a sort of talking points type person or high level notes. She literally wanted pages of verbatim. So you had to have a fair bit of detail with Melissa. So that was, type of thing that I had to help prepare. And I suppose I also had a bit of a quality check role as well, because at this time, I think it's fair to say that Minister and Catherine and Melissa had sort of lost a fair bit of confidence in what they were being told from the compliance division.
What do you mean by that?
Well, they didn't believe what they were saying was accurate.
And how do you know they didn't believe that?
Because they told me.
Okay. And when you say they didn't believe what they were being told by the compliance team, did they mention particular persons?
I think over time I would have heard comments about Miss Harfield, who was the general manager at the time. Mr. Britton had left, but Jason Ryman was another person that they'd made negative comments that he doesn't know things. During this time, there was quite a number of examples where, say, Minister Tudge would ask what happens with, a particular question, maybe how do we treat vulnerable cohorts? Compliance division would prepare an answer, I'd do it up, it'd go to the minister's office, they might come back with a follow-up question, okay, how's this work? And then compliance division might change their mind on what they originally said under a bit of pressure. So you don't do this, you do that. Oh, yes. And so the senior people that I've mentioned soon became wary that these people knew what they were talking about.
All right. So you mentioned that there was a high level of media activity in relation to the program in early 2017.
Yep.
Did you understand that, and that media activity was generally negative reporting about the scheme?
Yes, all negative.
And the general theme of that reporting was that the scheme was unfair.
Yes, that would be fair summation.
And would it be right that you understood that negative reporting to present a risk to the department?
Oh yeah, it was definitely negative to our reputation and the reputation of the government.
By the government, you mean the political side of...
Yeah, the executive, yeah.
And am I right that you saw your role as, in responding to these various public inquiries and the media, to push out the department's narrative in relation to this negative reporting? Would that be right?
Yeah, try and counter some of the misreporting and misinformation that was happening at the time. There was certain things that we had done poorly that was being highlighted, but there are things that we weren't doing poorly that was also being reported. So the role was to get on top of those issues as much as possible.
And how did you arrive at your understanding that was part of your role? Were you told by someone that was part of your role?
I don't recall. I would have just thought that that was my role given my background, and they've brought me in to help manage what was a crisis. So I would just thought as a Band 2 officer with extensive central agency experience, that's the expectation, that you can handle the media, you can handle these issues, you can handle the small p political stuff that's going on.
So, in using the word crisis, that is how you described the media situation in relation to the Robodebt scheme in early 2017?
Yeah, no, I definitely think I arrived at 2017, it was a crisis. It was in the middle of a crisis.
Right. And then, of course, in early 2017, the Ombudsman commenced an investigation into the Robodebt scheme.
Yeah, I don't know when, but yeah, around about that time, yep.
All right. And you became involved in responding to that investigation as well, didn't you?
Yeah, especially as my role evolved into this transformation of the program role, I became a lot more, it wasn't so much about issues management of day to day, but actually transform the program, change the program. And so the Ombudsman was obviously trying to look for changes to the program, so that's where I became quite involved.
And you were involved in responding to inquiries by the Ombudsman?
Yes.
And providing information to the Ombudsman?
Yep.
And did you understand that your role that we just discussed before about pushing out the department's narrative extended to doing that with respect to the Ombudsman's inquiry?
Yeah. No, we would have made sure that we had alignment with our messaging externally, including to the Ombudsman. Yep.
And when you say alignment with messaging externally, that is ensure that a consistent message was provided, that is a message consistent with what was being done publicly in respect of other matters, be pushed out towards the Ombudsman as well.
Yeah, and the clear example is the 20% error rate that was being reported in the press at the time which was just completely untrue, but that was being used all the time in the press.
Would this be right? The Ombudsman inquiry represented a risk to the department in that it might result in findings and recommendations that were adverse to the interests of the department?
Yeah, it could be, but I think I took the view that it was more an opportunity than a risk. But yes, there was a risk, obviously, if they came up with negative comments or pushed us to do things that were beyond our capability, then that would be a negative.
So in other words, come up with negative comments that would further damage the reputation of the department?
Yes.
And then come up with recommendations that, from the department's perspective, were unworkable?
Yes, that would be negative.
What was the opportunity presented by the Ombudsman investigation?
Well, from my perspective, the Ombudsman could recommend things that would involve transformation of the program, which internally for me would mean that I'd be getting access to more resources to implement those changes. So the opportunity was if the Ombudsman said change a letter, I would be able to get ICT resources to change a letter, as opposed to Jason has a bright idea to change a letter.
What about an opportunity to get the Ombudsman to make findings that aligned with the department's narrative?
Well, it's useful if the Ombudsman has the correct reflection. As I said, the criticism of the agency is not invalid, but things like the 20% error, which were completely false, it was useful if someone else independently looked at the data, looked at the issue and came to the same conclusions we had. That was useful. So if we could influence them to do that, that was definitely part of what we wanted to do.
So the Ombudsman's an independent statutory investigative body.
Yep.
And it would be useful if the Ombudsman would make findings that were consistent with the department's messaging.
Yeah, and with the facts. And with the facts.
All right. Could this document be brought up on the screen? CTH.3005.002.3363_R, Exhibit 1329. We can just scroll down to the bottom of the document. Next page up, thank you. Now, I just ask that the section headed original message be called out, please. All right, you can see this is an email from Louise McLeod to Michael Robinson on the 30th of January 2017. Do you see that?
Yep, I do.
All right, now who's Louise McLeod, to your knowledge?
Louise was one of the senior people in the Ombudsman's office.
Right, so we can see signature block, the bottom of that image, Senior Assistant Ombudsman.
Yep.
Who was Michael Robinson?
So Michael Robinson was one of the national managers in the agency who handled the Ombudsman liaison area. He was an SES Band 1.
Sorry?
He's an SES Band 1.
Thank you. And the subject is outline of OCI own motion investigation report.
Yep.
Oh, and I should mention it's also addressed to Jason Ryman. Do you see that?
Yeah, I do.
It says, "Hi Michael and Jason, as flagged, please find attached the proposed outline for the own motion investigation report into the OCI.
Yep.
This document reflects our initial observations and initial recommendations to be covered in the report.
Yep.
We're aiming to provide the department with the draft text for part 2, introduction and scope, and 3, background of the report early next week. In the meantime, we'd welcome your initial comments, points of clarification or feedback on the outline, and can meet later this week to discuss if this will assist." So
Yep.
we go to the next email in the chain. Call that out. Should be the email from Mr. Robinson to Ms. Harfield, dated the 30th of January 2017. Can we call that? Sorry, next one up. Oh, sorry, we'll deal with this. So this is an email from Mr. Robinson to Karen Harfield, dated the 30th of January 2017.
Yep.
It says, "Karen et al. This attached has just arrived from the Ombudsman's office. We'll read and be back in contact shortly to consider any initial response DHS might like to make, and in the meantime would appreciate you considering the same."
Yep.
And if we could go to the next email. No, next one down. Thank you. Email from Mr. Robinson to Karen Harfield, dated the 30th of January 2017. says, Karen, having read the report outline, I think the department has been given a great opportunity to effectively co-write the report with the Ombudsman's office. Given the time pressure the OO is under, any suggested wording you provide in response to their dot points will enable them to do a quick copy and paste in many instances. See that?
Yep.
Where there is general agreement or at least not totally opposing views.
Yep.
And then there's an invitation for information or request for information. And then if we go to the last email in the chain, again from Mr. Robinson, forwarding the earlier emails to you.
Yep.
Dated the 1st of February. And it says, FYI, self-explanatory. I'm sure that there is some commonality in what the Ombudsman's report will say and what you will include, address in your inquiry, input and sub. I'm just not sure how to align them all together so they look coherent. Happy to have your suggestions.
Yep.
Now, just coming back to what Mr. Robinson said in his email on the 30th of January, the previous email.
Yeah.
Do you recall reading those words?
Oh, no. I don't recall those.
Do you recall, so you don't recall Mr. Robinson forwarding you an email in which he said the department has been given a great opportunity to effectively co-write the report?
I don't remember that.
You don't remember that?
No.
What is your understanding of the words to effectively co-write the report mean?
Well, I think what Michael's probably suggesting there is that we can provide a fair bit of input, and as long as they're agreeable, that they'll accept our input. They're open to accepting our input, which is good. There's an opportunity to work with them. They're open-minded to content. And if you're writing this to Karen, it's more likely the technical aspects of how the program operates, which, you know, they'd want to, the more they can get access to documents and wording, the better, from their point of view.
What about the words, given the time pressure the OO is under? What do you understand that to be referring to?
I don't know. I don't know what that's referring to.
Well, what I suggest Mr. Robinson is saying is that the Ombudsman is under significant time pressure to complete its investigation, and this is an opportunity for the department to effectively cut and paste tranches of its own wording into the Ombudsman's report. Do you agree with that?
I think we can definitely put material to them. Yeah, it's an opportunity to put material to them, yeah.
Well, it's not just put material to them, it's cut and paste tranches.
Yeah, but the Ombudsman's an independent statutory office holder. If he wants to reject our words,
Well,
it's up to him.
well, the time...
But there's nothing wrong with suggesting wording. This is fairly normal practice with both Ombudsman and ANAO reports, as you suggest, very detailed. How about you change your recommendations from this to that? Fairly normal practice. In my experience, it's fairly normal practice for both the Ombudsman and the Auditor General to reject those suggestions, but APS agencies do that all the time.
cut and paste words into the
Yeah.
independent body's report.
But in the end today, the Ombudsman's signing off the report. He's not happy with it. He's not going to sign off on it. He's going to say, sorry, no. It's quite normal. It's quite a normal practice. And as I said, my experience, some people are open to putting in wording changes, some are not. I would say that the current Auditor General is not someone who takes on board commentary very readily, but you still give it to him. You don't not. It's part of your role to put forward, we think it would be better expressed this way, we think the facts actually suggest this. Open to him to reject the suggestion or to accept it.
Is it normal to I'll withdraw that. If we go to the last email, return to the last email in the chain. That is the email to yourself forwarding the earlier emails. Now, I'm just asking you about the words. I'm sure that there is some commonality in what the Ombudsman's report will say.
Yep.
And what you will include addressing your inquiry, input and sub.
Yep.
What is the input and sub, sorry, the inquiry input and sub to your understanding that's being referred to there?
Yeah, I'd say given the timing, we're probably talking about the Senate inquiry that had been called. And possibly at this stage in the timeline, I was probably still drafting our inquiry. So we made a submission to the Senate inquiry, and at this time I might have been sort of leading that draft, but ultimately there was a new team was formed that I wasn't part of or responsible for that actually did that. So that's probably at that time why he's referring to that to me.
So what do you understand the words there is some commonality in what the Ombudsman's report and what you will include addressing your inquiry input and sub?
Well, it's just more facts and language. So if we're going to put towards here's how the program works and explain that, it'd be useful if we were all using the similar type of language and similar type of wording and data.
In other words, consistency of message.
Yeah, but it's also consistency of language. Like that can be important. If people start referring to something as, these measures had 50 different names. Do you refer to it as OCI or do you refer to it as something else, as the income compliance program? That's actually really important if you want to be able to say we're talking about the same things.
Okay. So you don't accept that what's being referred to here is the desirability of consistency of public messaging in respect to the program with what's being said to the Ombudsman?
It's desirable. Whether it's achievable is another issue. So it is desirable from our side of the fence that there is consistency where it is possible. Where it's not possible, that's fine. But where it is possible, it's sort of like if we're saying the 20% error isn't an error, and he's also saying it, but he's saying it in slightly different language that everyone interprets differently, that's actually not that helpful. He's still got the same conclusion as us, but people read it differently and therefore they come to a different conclusion. That's actually unhelpful to us. So if we can influence his language to be more like ours and influence his conclusions that he's already verbally talking to us about to align with us, that's useful for us. It's not essential, but it's useful. If we can achieve it, it'd be great.
Right, that can be taken down. Could this document please be shown? Doc ID CTH.3001.0039.3863_R. Exhibit 1415. Now, you see that's an email from Mr. Hudson.
Yep.
To Ms. Campbell.
Yep.
You're one of the people copied to the email.
That's right.
It's dated the 17th of March 2017.
Yep.
Can we just call out the body of the email? It says, Catherine, for your information, this afternoon I met with Annette, which must be Miss Mussolino.
Right.
Jason, that must be you.
Yes, that's right.
And others. Met with Richard Glenn, AG Ombudsman.
Yep.
That was the acting Ombudsman.
That's right.
And his staff working on the OCI report.
Mm-hmm.
The meeting was productive, agreeing a finalisation process and key changes to recommendations and findings.
Yep.
See that?
Yep.
And it says it was agreed that the Ombudsman's Office would develop a new draft report based on today and additional material discussions. See that?
Yep.
Then says the new draft report would then be the basis for a formal reply from you. There would not be a need for you to reply to the current draft. When we received the next draft, we agreed that we would seek to have a formal reply from you a week from receipt. Do you see that?
Yep.
And then further down to the middle, it says they agreed that the following recommendations would need redrafting.
Yep.
DHS will provide alternates for their consideration.
Yep.
And then towards the bottom in the last paragraph, Jason to work developing the documentation to take the Ombudsman through our proposed changes throughout the report.
Yep.
Meeting with Ombudsman's Office to be arranged for Monday or Tuesday. You see that?
Yeah. Yep. Yep.
Now, do you recall a meeting at about this time involving yourself, Miss Mussolino, and the acting Ombudsman?
Yeah, and I remember going to this meeting. Yep.
Okay. And am I right that what was discussed was a then draft of the Ombudsman's report?
Yes. Yep.
And am I right that you and perhaps Ms Mussolino raised some issues that the department had with the draft?
Yeah, no, that'd be fair comment. I think that's the nature of the discussion.
And was the effect or the outcome from that discussion that the Ombudsman's Office would develop a new draft of the report?
Yes.
To address the issues that you and Ms Mussolino had raised about it, the earlier draft?
Yep. That was the agreed process out of that meeting.
And they agreed that a number of recommendations would need redrafting,
Yes.
and that alternate draft recommendations would be provided by DHS to the Ombudsman for the Ombudsman's consideration.
Yes.
And then you were to work developing documentation to take to the Ombudsman through proposed changes to the report.
Yeah. Yeah.
And then there was to be a meeting arranged the next Monday or Tuesday in relation to those proposed changes.
Yep. That sounds right.
Okay.
And the Andrew Aston who is to be kept informed of progress was?
Minister Tudge's Chief of Staff.
Thank you.
Was there some, did you have an understanding that the Minister's Office needed to be kept informed about the progress of this matter?
The Minister's Office needed to be kept informed about the progress of anything to do with this program after it went off the rails at the start of January. It was hypercare. There was anything that went with the program, you had to talk to the Minister's Office.
Was that a message that was communicated to you?
Well, I don't think, as a public servant, as a general rule, you don't want ministers and ministers' office to be surprised by things, and you certainly don't want them to be reading in the press. So keeping them fully informed of everything that was going on that could potentially be an issue for them was very important. Very important about trying to manage and regain trust from the minister and his office.
But that's not something that's done with every program that the...
No. This program's under hypercare from January 2017.
Hypercare, a term used in the public service?
Yeah, I've heard it used. Yep.
And did someone say that this program, to you, this program is under hypercare?
Yeah, either Catherine or Melissa had mentioned that that's where we're at with this. We can't do anything without being extremely cautious from here on in.
And did they communicate to you that the minister needed to be kept informed of everything to do with the program?
Yeah, yes, they did, and my meetings with the minister would suggest he needed to be kept very informed about the program. Minister Tudge is a details person, and he was very interested in the detail of what was going on.
Okay. And just before we move off this document, if we can just go to the top of it and note the date. This was the 17th of March 2017.
Yep.
See that? So that document can be taken down. Can we then please have up document CTH.3005.0003.6060_R, Exhibit 1420. Now, Mr. McNamara, you recall that the previous email I just showed you was dated the 17th of March
Yep.
2017.
Yep.
And that it flagged the possibility of a further meeting
Yep.
following Monday.
Yep.
And you can see here, it's an email from Mr. Robinson to Ms. McLeod,
Yep.
dated the 20th of March 2017.
Yep.
So that is the following Monday.
Yep.
And you can see the attachments, track changes to draft own motion report, 20 March 2017, noted there. Can you see
Yep.
that? And you can see you're CC'd into this email.
Yep.
And you can see the text of the email from Mr. Robinson says Louise. And Louise is Louise McLeod, who we've established before was from the Ombudsman's office.
That's right. Yep.
Attached is the marked up version following today's discussion and some feedback from other areas that I've incorporated. They'll show as being inserted by me but actually come from others, including Annette's suggestions around the 10% issue.
Yep.
I've also included a correct letter for Appendix D. See that?
Yep.
Now, I just want to ask you about the words, some feedback from other areas.
Yep.
Given that you're CC'd into this email,
Yep.
would you have provided some of that feedback?
Yes. Yes.
Thank you. That document can be taken down. Next document is CTH dot 3005.0003.6061. Exhibit is 1420. Now, Mr. McNamara, this is the attachment to the email that you were just shown.
Mm-hmm.
We can just go to page 1 of X and see at the top the words executive summary.
Yep.
And you can see markings in the document in track changes.
Yep.
Can we take it that wherever the markings and track changes appear in this document, they are changes that were marked by officers of DHS?
Yeah, no, that'd be a fair, if that's attached to Michael's email, that would be a fair conclusion.
And these are the words that DHS were proposed, where words are added, they're words that DHS is proposing to be added to the report.
Yep.
And where there's strike-throughs, that's deletions that DHS is proposing to the draft.
Yeah, that'd be fair. Fair summation. Yep.
Okay. Can we then just call out the third last paragraph on that page? The nature of administrative decision-making is that decisions are made on the best available information,
Yep.
and if further information is provided, a new decision is made.
Yep.
This applies to all DHS business as usual activity.
Yep.
With the OCI, it is vital that the customer responds to the request for information from DHS so decisions are made on all available information.
Mhm.
Importantly, if a customer identifies new information, they can provide this to DHS and ask for a reassessment any time, including after a debt has been raised and or paid.
Yep.
See that?
Yep.
So those are words that have been added by someone from DHS
Yep.
to this report drafted by the Ombudsman.
Yep.
And these words, am I right, are consistent with the department's messaging at the time about the program.
Yeah, they would be. Yeah, they are.
And the reason why they would have been added to this report is to ensure that this aspect of the department's messaging is reflected in the Ombudsman's report, correct?
Yes, and the facts are these are a fair few facts about how we think about the program. So yes,
Well, it's how DHS thought about the program.
yes, that's right.
And what you were asking was the Ombudsman to adopt those words.
Or adopt words or adopt those thoughts. Yeah.
And it was important that an independent statutory investigator adopts words such as this to confirm the department's messaging.
Oh, it's useful if they do. Yes, definitely.
Because that would add weight in the public mind to what the department was saying about these matters, correct?
Yeah. Well, in March we're still in the middle of a crisis. We're still in the press every second day. So yes.
Okay. Now, if we go, please, to page 2. Call out second paragraph under the heading Transparency and Usability. Now, you can see the words there in that passage, Mr. McNamara.
Yep.
Now, can we take it that the words in underlining are words that have been added in this track change process?
Yep.
By the department?
Mm-hmm.
And the strike-through is made by the department?
Yep. No, that'll be right. Yep.
Now, the effect, so the words that were struck through were the words inaccurate debts,
Yeah.
and without the words added, the sentence would have read, this resulted in accurate debts for people with fluctuating or intermittent income.
Yeah. Yeah.
But those words, inaccurate debts, were removed.
Yep.
And with the additional words, the sentence read, this resulted in people with fluctuating or intermittent income having their income evenly apportioned, which in some cases was a more favourable outcome for the customer, and in others, the debt was overstated.
Yes. Yep.
And you'd agree with me that the effect of this change was to produce a sentence that was less negative about the program.
Yes. Yes. Definitely. Definitely.
And that was the point of making this amendment, so that the words were less negative about the program.
Well, yes, that's part of it, but our legal services division, because this is something the Ombudsman raises, like they raised this again in 2019, inaccurate debts, and our legal area did not like those terms because I think the Ombudsman's office was using them in a generic sense, and our legal people were going, well, you're saying it's inaccurate in a legal sense, and it's not. And so they used to discuss the matter, is how I'd put it.
So that was the position of the legal section of the...
Yeah, because in 2019, we work with the Ombudsman Office on a flyer to explain income averaging, and the Ombudsman Office makes similar type of, your debt could be inaccurate type things they wanted in the flyer, and our legal division didn't like that at all and said that, no, we can't say that, that's untrue.
So a part of the department didn't like the wording that was in this draft.
Yep.
And caused that wording to be changed.
Yes, yeah. They didn't agree with it. Not the lawyer here, but they didn't agree with it as a matter of law that it's an inaccurate debt, so they didn't want that in the report.
Mr. Scott, it's 11:25. I'm wondering if we should take the morning break.
Yes, Commissioner.
It's a convenient time. All right. We will resume at 22. Thank you.
All rise. The Commission stands adjourned until 11:40. Royal Commission is now in session. Please be seated.
Yes, Mr Scott.
Thank you, Commissioner. Could the document we were just looking at be returned to the screen, please? It was document CTH.3005.0003.6061, Exhibit 1420. Could we please turn to page 9? And call out paragraph 3.10. Can you see that passage there, Mr. McNamara?
Yep.
Again, what I'm interested in is the track changes. You can see the words that have been added.
Yep.
And the words that have been deleted.
Yep.
You can see that without those additions, but with the wording that was deleted, it would have read, the letter did not provide a clear warning that using average data may result in an incorrect debt.
Yep.
See that?
Yep.
Now you understood that that's a reference to the use of averaged ATO data to calculate a social security recipient's debt as part of the Robodebt process.
Yeah. Yep.
And that is taking the ATO data, which generally would cover a whole year.
Not necessarily, but yeah. At an extreme it would.
Beg your pardon?
At an extreme it would, but most ATO data, employment data we got wasn't annual, but yeah, it could.
So you're saying that ATO income data used in this process was not over an entire year?
It could be, but it would often have employment dates in it.
Periods of employment.
Periods of employment. So it may have 1 July to 1 October. That was normally, but it wasn't of high quality is how I'd put that, but it usually had dates.
Wasn't of high quality, what do you mean by that?
Well, the ATO, it wasn't important to them whether the employer had put accurate dates in or not. So they weren't checking it, they were just passing it to us.
I see. But insofar as the data covered a period,
Yep.
it would never be for a fortnight.
Oh, well, it could be, but no, generally not. Generally it'd be, because you wouldn't get a debt. So yes, generally it has to be several months worth of data from the tax office.
All right. And of course, social security entitlements are generally calculated according to actual fortnightly earnings, correct?
At that stage, yes, actual earnings, yep.
Fortnights.
Fortnights, yep. The Centrelink pay periods, yep.
And so what, under the Robodebt scheme, happened was if a recipient didn't engage after an initial letter,
Yep. 2 letters and 2 phone calls, yes.
well, however many contacts,
Yep.
the ATO data would then be averaged over each fortnight.
That's right, yes.
Can I just ask that 2 letters and 2 phone calls? I had thought when this OCI iteration of the scheme started, there weren't phone calls before the averaging. Is that not right?
You're right, Commissioner. I'm referring to the EIC and Q schemes,
all right,
not
thank
OCI,
you.
definitely.
And of course, in many cases, recipients of social security don't earn income in equal amounts per fortnight, do they?
No, they don't.
So using average data, as the wording of this passage originally stated, would often result in an incorrect debt.
No, I wouldn't accept that. At the time, our understanding of the law was that that was an acceptable way to estimate someone's fortnightly income.
I'm not asking you what your understanding of the law was, Mr. McNamara. I'm asking you whether or not the debt was correctly calculated.
Well, I think it's the same thing, isn't it? I mean, if it's a lawful debt, it's correctly calculated.
Okay.
Did you have any idea of the law that made this lawful?
No. This particular issue and how it was expressed here was very much Ms. Muzzolino's territory, and she was the one leading on this. And as I said, our Legal Services Division was very big on this is not an incorrect debt.
Okay, but just as a matter of logic, if you divide somebody's income over a year by 26, the figure you get is not necessarily going to be anything like what they actually earned in any given fortnight.
It's an estimate.
Well, it's a guess, really, isn't it?
Oh, it's an estimate. I mean, as an economist, we do that sort of smoothing all the time. It's an estimate. I agree it's not as accurate an estimate as using detailed fortnightly data of some description, whether it's bank statements or pay slips, but it's still an estimate.
All right, thank you.
We understood that social security entitlement under the law was defined according to what people actually earned per fortnight. Did you?
Yeah. Yep, that's right.
And under this system, using average data, you would not, in many cases, you would not arrive at an actual figure of what a recipient had earned per fortnight, correct?
You'd have to estimate it using this, yes. But you have to estimate it using pay slips too.
And you would have understood that in the context of the media attention at the time, that it was highly topical that average data was being used to calculate debts.
Yeah, no, the media was, it was a large topic of conversation and that it was very unfair to do it.
And that it would result in incorrect debts.
No, I disagree that was what the media was saying at the time. They just said it was unfair.
I see.
At this time, we're talking about 2017. Yep.
But in any event,
Can I just ask you, did you ever come across an article by Mr. Martin on Robodebt? He fairly uncharitably compared the scheme to the P76. I don't know if you recall that car.
No, I don't recall that, Commissioner.
It's an article from the 5th of January 2017, and he pointed out that it was a stupid mistake to calculate fortnightly income by dividing annual income by 26. He said if the figure was too high, then it would be said that someone was not entitled to benefits during the weeks they received them, even if during those weeks the person earned nothing. In other words, they misapplied the law. You weren't familiar with that article?
No. 5th of January is probably before I come into
Okay.
this.
Right, and Mr. Tudge's office never brought it up with you?
No.
Okay, thank you.
No, income averaging was brought up, but as a fairness thing in 2017.
so you did not understand there was any issue with the inaccuracy of the calculation of debts using income averaging?
No, Ms. Muzzolino was pretty definitive. This was a reasonable way. It was a sufficient accuracy and it was permissible.
I see. And in any event, that was what you've just described was the position of the department on that issue
That's right.
in the context of the media coverage about whether or not that was fair.
Yes.
And it was quite important, therefore, that the words in this passage not include the words, the letter did not provide a clear warning that using average data may result in an incorrect debt. Correct?
That's right, because we didn't believe it was an incorrect debt.
And so it was therefore important to make these amendments that we've got on the screen here to the Ombudsman's report.
Yeah.
Can we go to page 14, please? And call out paragraph 3.22. Now again, can you see the words that have been deleted from this passage? Mr. McNamara?
Yeah, yeah, yep. Yep,
And the inserted words underlined?
yep. Yep. That would have been March, yeah. That's what would have been our thinking in March.
So what's the significance of adding the words "they have made genuine and verified attempts and other available information does not provide sufficient evidence to clarify differences in reported employment income information"?
Oh, we wanted them to try and get their pay slips. So we wanted them to come to us and say, I can't get the pay slips, the employer's gone broke, or, you know, I can't go back to that employer, we left on bad terms. We wanted them to actually try and engage and actually try and do. Essentially, the program is about the customer doing the review, not the agency. So we wanted them to do it first before we'd go and do things.
By them you mean
The customer. Or
the income
employer.
recipient?
Yeah.
And that was effectively the policy position of the department?
That was effectively how the program had been designed
And so,
at that time.
yes, and so what's being recorded there reflects what the department wanted Social Security recipients to do.
Yeah, and I think at that time that's accurate. I would say not too long after this, we definitely softened our stance on that, and we definitely made it clearer that we would accept bank statements and that we would provide more assistance with bank statements. So this is still a fairly harsher line in March 17 that probably doesn't last another 6 months.
But in any event, these are words that the department sought to be inserted in the Ombudsman's report.
That's true. That is true. Yep.
And the opening statement, DHS has always accepted bank statements, wasn't literally true, was it?
We did. As far as I know, we always did accept bank statements. But my understanding, Commissioner, from the Compliance Division was that we would only do that with the customer and with the customer's permission. So we would never unilaterally use our powers to go and grab bank statements. We would only do it at the request of the customer.
But at the start of OCI, when people were being told to upload their information,
Yeah, you couldn't use bank statements then.
no. So it wasn't true that DHS always accepted bank statements, because at the start of the OCI, they didn't.
Yeah. I think this is sort of referring to time and a longer period of time and not the actual OCI program itself.
Okay, thank you.
Can we go then, please, to page 27? And just call out recommendation 1 and the box in grey immediately below it, please. Now, you can see there, Mr. McNamara, that section's dealing with a proposed recommendation by the Ombudsman relating to the 10% recovery fee.
Yeah.
And you would recall that an issue in the Ombudsman investigation was it was identified that DHS was automatically applying a 10% recovery fee in respect of debts raised under the program.
Yep.
And you recall that DHS, in the course of the Ombudsman inquiry, indicated that it would revisit that practice.
That's true.
And this recommendation was to deal with recipients who'd already been the subject of the application of that fee.
Yeah, we were running a service recovery program on the people who'd gone through OCI at this time.
Okay. And you can see the words taken out from that recommendation that are in the strike through.
Yeah.
And you can see the words that are added to that recommendation.
Yeah.
And is the effect of that change that it would mean that there would have to be less customers in respect of whom there would have to be reconsideration of the application of the recovery fee?
So it had to do with, Miss Muzzolino will be better placed to answer questions about this because this is the one she would have been leading on. But it had to do with the fact that we had to have a reasonable excuse from the customer to not apply the 10% recovery fee. So by definition, that had to be the people who we hadn't contacted successfully.
Right. So what's the difference between the original form of the recommendation and the new form?
Yeah, I think that's probably a question for Annette. She was the one leading on this, and she had a bit of a bee in her bonnet about what they'd worded and what she wanted to change to. So I was an interested observer at the meetings about this, but in terms of this particular recommendation, I probably can't help you a lot there, Mr. Scott.
Okay, we'll go to page 29 then. Call out recommendation 6 in the grey box. Now you can see some amendments to that recommendation
Yeah.
in strike through, and then some additional wording. And the additional wording is that in respect of, or after rolling out further the OCI system,
Yeah.
current and former customers with a payment nominee who is either court appointed or an organisation, and current customers with a homelessness indicator should be included in the current vulnerable assisted cohort.
Yes.
Now, what's the significance of the vulnerable assisted cohort?
So it's essentially a non-online process. Depends on the person, and I'm trying to think back at the time. I think we might have started with a phone call rather than a letter. But anyway, it's a staff-assisted process through the whole. I don't think they even had access to the online system.
So instead of a customer receiving a letter and then having to update their information online, they'd get a phone call.
Yeah, that was the theory. Don't think it was necessarily the practice in 2016, but that was the theory of the system.
And it was in respect of customers thought to be vulnerable.
Yeah. So vulnerability in Services Australia at that time is it's an indicator on New Start. So if you were in mutual obligation, you could be vulnerable, and therefore you didn't have to meet your mutual obligation. And in our systems, you'd be ticked as vulnerable, and that's the reason. We would then reuse that vulnerability indicator in the program.
Okay. And is this right, that what's being contemplated by this recommendation is expanding the categories of customers that might be thought to be vulnerable for the purpose of this program?
Yeah, that's what the Ombudsman wanted. They were very particular about this, and it might be our wording, but I think it was very much them. It was just, we were drafting it in a way, but that was their want. We discussed this in detail, and they wanted payment nominees.
And the effect of it would be, by expanding the cohort of vulnerable customers, that you would be expanding the numbers who would be dealt with by this alternative process that didn't involve the online platform.
Yeah, that was the idea.
And with respect to customers in that cohort, completing a review under the OCI process was slower than for the general population who were dealt with on the online population platform.
Yeah, they would have more time because they'd be dealing with a staff member, yep.
And more resource intensive.
Yeah, that's right.
And it was in the department's interests to minimise the numbers of persons within the vulnerable cohort, to therefore minimise the resources that would be needed to deal with them.
Oh, yeah, I think our motivation in excluding vulnerability around about this time was actually more the minister he'd made it clear we were not to prioritise any reviews of anyone who would be considered vulnerable in any way, shape or form. So even though this recommendation existed, from about this time onwards, we excluded vulnerable people altogether. There was no manual process or online process. There was no process. They weren't chosen for review.
I see. But until that occurred,
Yep.
it was in the department's interests to minimise the number of customers that would be dealt with on the manual process for vulnerable persons, wasn't it?
Yeah, we didn't want to, at that time, we still would have had fairly limited staff on the program. We would only had about 400 people on the program at that time.
What about the customers who weren't digital ready? Whose idea was that? I'm looking at the B on that.
Sorry, Commissioner?
See, B, DHS should explore building into its service delivery systems a flag.
Yeah, it's an interesting concept.
Whose concept? Was that the Ombudsman's?
Yeah, Ombudsman concept. The trouble, Commissioner, is we don't have a customer system in the agency. We have 24 million customers, but we don't have a customer system. So it's a nice theory, but it's just not possible because we don't have a customer system. We got nothing to put it on. So that...
Right. You've lost me, so just explain that.
Okay, so Australians' records are not held in a consolidated form in our systems by the person. So you can't call up and say, Jason McNamara, here's my CRN, and the service officer would bring up your entire history and everything to do with you. We've got workarounds, but we don't have a centralised system. So that's not the way our systems work. So this is a nice concept, but we've got nowhere to store it, if I put it that way.
So what do you know about a given customer, as you were calling them?
Well, as I said, it can be quite limited, but the way our filters work is we try and go into what we can associate with the customer's record. So vulnerability by its definition is a very difficult thing for us to practically do. It's easy to say these people should be excluded. It's quite difficult to actually, in practice, find those people to exclude them.
So homeless people, for example, how do you sort that out?
So homelessness is something because you apply in terms of payment that is noted in our system. So that's relatively, but yeah, so you associate some characteristics with your CRN, so domestic violence, homelessness, but we just don't have a nice, neat way of going, yes, we can easily pick out your characteristics and exclude you. To do those filters as we do in data matching, it's quite a manual intensive process.
And you mentioned before something about vulnerability in the New Start context.
Yes.
What about for youth allowance? Was there any flag that would exist for youth allowance that would tell you someone was vulnerable, or is it just not that kind of payment?
I'm not an expert in the payments. I know it was there for New Start because there was mutual obligation. If there was mutual obligation, it would be there for the other payments where there was mutual obligation. But it was mainly New Start from memory.
All right, thank you.
Thanks, Commissioner. This document can be taken down. The next document is CTH.3005003.6677_R, Exhibit 1423. Call out the email at the bottom of the chain. Email from Louise McLeod, dated the 23rd of March 2017, to Mr. Robinson. It says, "Hi Michael, please find attached a copy of the marked up report following our consideration of the comments provided by DHS to date. Yep. Let me know if you'd like to meet again to discuss."
Yep.
And then if we go to the email at the top, call out email Michael Robertson to yourself and some others. dated the 23rd of March 2017.
Yep.
Forwarding the draft report. And it says, Jason and Alison, hot off the press and unexpected, a final bite of the cherry.
Yep.
Do you recall receiving this email?
No, I don't.
Is it consistent with your recollection that the department had a number of opportunities to provide comments in respect of the draft report?
Yeah, no, I recall that we did interact on the report a number of times, yep.
That can be taken down. Our next document is CTH.3005.0003.6819_R, Exhibit 1424. Oh, sorry, not that one. Sorry, not this one. It should be CTH.3008.0017.1268_R, Exhibit 1425. Okay, now, you recall we discussed a little while ago the draft report and the recommendation 6 that dealt with nominees.
Mm-hmm.
I'll just call out the first paragraph from the second last email on the chain from Melissa Ryan, dated the 23rd of March 2017.
Yep.
Sorry, that should be the first two paragraphs of that email. Now it's addressed, you can see, to yourself.
Yep.
And Alison. It says, we have been provided the opportunity to review the draft own motion report, in particular paragraphs 3.35 to 3.41 and recommendation 6. In reviewing the content and the recommendation, we suggest that payment nominee be replaced with correspondence nominee. A correspondence nominee has greater responsibilities and authority to act on behalf of a customer. This would address a number of concerns the Ombudsman's Office has with addressing customers with vulnerabilities.
Mm-hmm.
Now, you recall the Ombudsman's Office expressing concerns about customers with vulnerabilities in the course of this investigation?
Oh, yeah. No, that was a key issue for them, was that people with vulnerabilities were being reviewed. Yep.
Sorry, I didn't...
People with vulnerabilities were being reviewed. That was a key concern of theirs.
Right. And would this be accurate that you understood that the scheme should be less... The Ombudsman's concern was that the scheme should be less onerous on customers with vulnerabilities?
Yeah, no, that'd be a fair call. Yep.
Okay. I call out the last email on the chain from yourself, dated the 23rd of March 2017, at the top of that page. You see your email in response?
Yep.
Thanks, Mel. This recommendation has been crafted quite deliberately in the department.
Mm-hmm.
Payment nominee limits this measure to a small group of people. Correspondence nominee would have picked up nearly 10% of letters this year, mainly students who are sending us mail to their parents. So on cost grounds, this would not work.
Yep.
Now, you're responding to the proposal from Melissa described in the previous email.
Yep.
And particularly the passage that I just caused you to be shown.
Yeah.
And am I right that you understood Miss Ryan to be proposing a slight variation on the recommendation that was being under discussion in this email?
Yeah, she was proposing a wider group of people to be covered by the vulnerability indicator. That's how I read it.
Perhaps if we go back to that passage just so we're clear.
Maybe I'm misreading it.
Just the first two paragraphs in that email. So what do you recall the term payment nominee as distinct from correspondence nominee to be referring to?
So in our systems, you can be someone who can accept correspondence. So, and what we're talking about later on here is it's quite normal for people to go off to uni and leave their correspondence address and where they want their letters sent to their previous house with their parents. They may have moved interstate, but they'll stay there. They're not vulnerable. They're just saying, yeah, my parents can receive the letters and that's fine. Where what we were trying to get to is who's a nominee who is actually vulnerable. So not all nominees are vulnerable. And what we were trying to get to was the people who would have a nominee and would be vulnerable. And that was, and it's, again, our systems are not great at being able to pick those people up, but that's what we were trying to do. Where I think Mel's suggesting, why don't you just put everyone in who's got a nominee?
Right.
And it's like, well, yeah, but then we're picking up people who aren't vulnerable.
So if we go back to that passage from that email that we were just discussing, the email from yourself in response.
Yeah.
So was the point that you were making that if the recommendation were recrafted as suggested by Melissa,
Yep.
it would mean that a great many more recipients would be covered by the recommendation?
Yeah, definitely.
And,
Who weren't vulnerable.
right, and that the point you make is that on cost grounds that would not work,
Yeah, that's right.
and that was your concern, the cost that would be involved.
Yeah.
Can be taken down. Next document is CTH.3005.0003.7980_R, Exhibit 1430. Sorry. It should be 3005.0003.7980_R. All right. Now you can see that's an email from Ms. Mussolino
Yep.
to yourself,
Yeah.
dated the 27th of March 2017.
Yeah, she wanted it changed again. Yep.
And the email is, as Jason has discussed earlier this evening, I'd appreciate your comments on the response we have proposed to the Ombudsman's Office on recommendation 1.
Yeah.
That was the recommendation about the recovery fee we were discussing earlier.
Yep.
And in that grey box, that's the original recommendation.
Yep.
That is from the earlier draft
Yep.
that she's referring to in her email.
Yeah.
And then the words in the paragraph below that. Our concern about this recommendation was its potential breadth. It potentially requires proactive engagement with anyone who has had a debt recovery fee imposed since the commencement of the OCI in order to ascertain their circumstances so that the decision about whether to impose the debt recovery fee can be reassessed with reference to new information, namely whether the person had a reasonable excuse.
Yep.
Now you understand and understood that this was in the context where the Ombudsman's position was that the recovery fee had been improperly imposed.
Oh, I don't think improperly. I think his view was it's unfair because you don't know. So Annette's point was always we can't not apply it unless there's a reasonable excuse, and the Ombudsman position was, well, because you've unilaterally raised the debt, how would the person give you a reasonable excuse? You didn't give them the opportunity, and therefore you should remove it.
And so that's the point, that the recommendation is addressing these people who had had the recovery fee imposed on them unfairly.
Yeah, definitely.
And that the concern of that was being expressed by Ms Mussolino was how many of these social security recipients would get the benefit of this recommendation.
Yeah. No, that's, although I think we went and reassessed everyone anyway, so, but yes, that's her, that's what she's saying there.
And you can see the proposed wording in bold below.
Yep. Yeah.
You read that?
Yeah, that's where no, that's right.
And the effect of what was being proposed with this reframed wording was to narrow the scope of the recommendation, correct?
Yep, it was.
When you said we reassessed everyone, what do you mean? Did you reassess everybody who'd had a recovery fee imposed?
Yeah,
All of them?
yeah. We did. Everyone who was subject to OCI went through a service recovery process to make sure that they knew their review rights. We contacted them. We didn't send them to debt collectors until we then knew that they had a debt and that they knew their review rights, and we gave them the opportunity to remove the recovery fee by talking to them about it.
But they had to make the application, did they? You didn't?
Yeah, because we'd applied it, they have to come to us to give us a reasonable excuse. So that was but we were reaching out to them proactively as part of service recovery to do that.
Did anybody talk about the basis on which it was imposed in the first place? I mean, why was it being imposed?
Well, my understanding, and again, this is more Ms. Alino than myself, my understanding is when we raise a debt, to not apply it, we have to have a reasonable excuse from the customer.
So your idea was that anybody who had any kind of social security debt as a result of an overpayment had to have a recovery fee imposed?
No, had to tell us they had a good reason why they had a debt. So they just had to give us a reasonable excuse. And a reasonable excuse could be anything, quite frankly. And when we went on to EIC, we sort of made it default that they always had a reasonable excuse. They had to tick the box to submit it that said, yes,
Yeah.
I've got a reasonable excuse. So
I wanted to go back a step further and work out why they had to pay a recovery fee at all. But
I think it's
reasonable excuse or nil.
I think it's the legislation, but I think that Ms. Alino would be a lot better placed to describe that to you than me.
Thank you.
All right, next document is CTH.3010.0040.6394_R, Exhibit 1441. Now, Mr. McNamara, you can see that's an email from Mr. Robinson
Yeah. Yep.
to Ms. Golightly and Mr. Hudson. It's the date of the 30th of March, 2017.
Yep.
Can you see that you're copied into the email?
Yep.
As was Ms. Mussolino. See that?
Yep.
And you can see, if we call out the first two paragraphs, it says, Ms. Golightly and Mr. Hudson, following a departmental discussion today, which included Jason McNamara, Karen Harfield, Anna Mussolino, Alison McCann, I had a teleconference with the Ombudsman's office to discuss issues in the draft report provided on Tuesday. The OO considered the comments and subsequently issued another draft report with multiple amendments, the majority of which were positive for DHS. In particular, a revised recommendation 1 based on DHS's preferred wording. Unfortunately, though, some editing appears to have had a negative impact, which I don't think is intentional, and I'll follow this up with tomorrow with the OO.
Mm-hmm.
Stating the obvious, of course, the OO is the Ombudsman's office.
Yep.
All right, and the revised recommendation 1, that's the recommendation 1 about the recovery fee that we've been discussing.
Yeah. Yep.
And the DHS's preferred wording would have been as per Ms. Mussolino's email that we just discussed.
Yeah.
Okay. That can be taken down. Next document is doc ID CTH.3004.0010.5247, Exhibit 1220. Now, do you recognise that document, Mr McNamara?
Yeah, that looks like the Ombudsman's final report, is it?
Yes.
Yep.
If we go to page 45 of that document, now you can see that purports to be a letter on Department of Human Services letterhead.
Yep.
And you can see the top right purports to be from the Secretary of the Department,
Yep.
Catherine Campbell.
Yes.
And if we go to the next page, page 46, you can see it's signed by her and
Yep.
dated 5 April 2017.
Yep.
Okay, if we go back to the first page, firstly, if we call out the first sentence, it says, "Thank you for the opportunity to comment formally on the proposed report titled Centrelex Automated Debt Raising and Recovery System."
Yep.
So this was a letter in response to a draft that had been provided by the Ombudsman's Office for formal response by Ms Campbell.
I'd assume so, yeah.
And we just noted the date of the document, which is the 5th of April 2017.
Yeah.
So this, of course, is after all of the engagements that the department has had with the Ombudsman prior to that time.
Yep.
Call out the second paragraph. Says the Department of Human Services, the department welcomes your finding that the department's online compliance system was designed appropriately, accurately calculates debts, and has undergone a range of enhancements that ensure its long-term sustainability. This will provide reassurance that debts were raised consistent with the previous manual debt investigation process.
Yep.
We call out the next paragraph. The department agrees with your assessment about incorrect reporting of error rates, information discrepancies which do not proceed to debt recovery action are not errors. The oft-quoted 20% error rate is incorrect, as you note.
Yep.
And as we mentioned earlier today, that was a key point of significance
Yeah, yeah, it was very significant. It was
from the point of view of the department.
a key point of misinformation in the press.
And then if we go to the bottom of that page, you can see the observation is made, as you have noted, continuous improvement by the department has already resulted in a series of changes.
Yeah. This is EIC, yep.
And then on the next page, the department agrees with all of your recommendations.
Yep.
Were you involved in the drafting of this letter?
Could have been, don't recall being, but yeah, could have been. This type of letter would have been typically produced out of Michael Robertson's area, but I assume Michael probably would have.
Well, you can see that the letter is highlighting areas of agreement between the department and the Ombudsman.
Yeah. We wanted to highlight. I mean, you know, the report is critical of the agency in lots of different ways, but we wanted to highlight the way they'd gone about it because they'd been very constructive. While they were critical, they were constructive. So they'd basically come to the point of view, which is what you're doing in EIC is really good. So that was positive for us. While their report contains a fair bit of language about how negative OCI was.
When you say they were constructive, that's in relation to the extensive negotiations that took place between the department and the Ombudsman as to the content of the report and its recommendations.
Yeah, they were, you know, they were open to change, but more importantly, they were open to practical recommendations that we were trying to do in transformation. They weren't just going to say, wave a magic wand and do something. They actually had, you know, tangible, practical suggestions of how do we have to improve this.
Right.
Which happened to be yours, didn't they?
Well, they aligned. So the point of these discussions was that we'd agree, they'd go, well, this is bad, what you're doing, and we'd say, yes, and we're doing something different. And so that's why it was important that we lined up because we had a meeting of minds on where the program had to go. You know, the agency was never going to be that happy with their comments in their report that were negative, but they were fair comments. So,
But that was always the reality, that there would be comments in the report that would be unfavourable.
oh yeah, and you know, not misplaced.
But the clear objective of DHS that you were involved in was, through this process of negotiation, prior to this point, that is the point of this letter, was to achieve a Ombudsman report that maximised areas of agreement between DHS and the Ombudsman in relation to the report's content and its recommendations.
Yeah, they were the only people out there who wasn't giving us an extremely difficult, unreasonable time. So it was great to have someone there who was constructive while being critical. So yeah, that was what I was trying to do. I was trying to influence them and cultivate that relationship so that they could be a constructive player in our transformation.
Now, the various earlier drafts of this report that were provided to the department for comment, they've never been published, have they?
No, I don't think so.
They've never been made public.
No, because I think, no, not that I know of.
And nor have any of the comments that the department provided in relation to those drafts until today.
Not until today. I don't remember any of them being FOI'd, but they could have been.
And the various negotiations that took place between the department and the Ombudsman as to the content of the report and its recommendations, they were never published to the world at large either.
No, it's not unusual to go through a myriad of drafts with any of these type of reports, and you don't publish all the drafts.
My impression, and you can tell me if this is wrong, is that you had ideas for the EIC, how you would modify things.
Yeah.
You put them to the Ombudsman, who essentially said, you should do these things,
Yeah.
which you had in train in any event.
Yeah. So that's what I'm saying, Commissioner. I by influencing them and getting them on board, they were both a discipline on us, made me do things in a particular time frame and came back, but equally it gave me a lot more resourcing and power internally to get ICT resources to actually do those changes rather than just have a good idea.
Yeah, I see.
Thank you, Commissioner. That can be taken down. Next document is CTH.3001.0047.3955_R, Exhibit 1657. Now, can we go to the bottom of that document, please? Sorry, the next page. Just call out the email at the bottom of that page. Now, that's an email from Rochelle Miller.
Yep.
The 21st of June 2017.
Yep.
To someone called Noel Tao.
Mm-hmm.
Do you know who Rochelle Miller is?
Oh, Rochelle Miller was Minister Tudge's media advisor
Okay.
at that time.
And the words are, "This is a politically motivated and factually inaccurate report reflecting the fact that Labor and the Greens don't support auditing of the welfare system." See that?
Yep.
Is that in reference to the Senate, the report of the Senate inquiry into the Robodebt scheme? Don't know.
Don't know.
Then you can see the next paragraph. The Ombudsman found that asking welfare recipients to explain discrepancies identified through data matching is reasonable and appropriate, and that the debts raised by the OCI are accurate, with these debts being based on the information available to DHS at the time the decision is made.
Yep.
You see that?
Yep.
And I suggest that this is consistent with the approach that both the Minister's Office and the Department adopted following the Ombudsman's report throughout the further iterations of the Robodebt scheme when adverse publicity happened in relation to that scheme, that is to refer back to the Ombudsman report.
Yeah, an external external reference was very useful relative to our spokesman just saying those exact words. Yep.
And that was consistently what was done.
Yes, no, it was a tactic used to, in a very difficult political environment, to respond.
Okay. And then if we go to the next email, which is on the bottom of the previous page. Headed from media, so it must be a standard media
Yep.
address. It says addressed to Ms. Golightly. You see that?
Yep. Yep.
1st of June 2017. It says, "Good evening, Melissa. For your information, Canberra Times contacted the department seeking comment on the Senate committee report."
Yep.
So does that refresh your memory at all about the significance of this?
No. Noel Tower kept writing stuff all the time, so I wouldn't remember one of his articles from another.
Okay. We go to the next email up, which is in the middle of the page. Email from Catherine Campbell to Melissa Golightly, 21st of June 2017.
Yep.
See the words? Very concise. That will be our referral.
Yep.
Do you have an understanding of what that will be our referral might mean?
No.
Okay. We go to the next email, the top of the page. From Ms. Golightly to yourself
Yep.
and others, 21st of June 2017. It says, "Please see instruction from the Secretary below."
Yep.
Do you recall this email at all?
No.
Can you assist us at all as to what the words "Please see instruction from the Secretary below" might mean?
Not really. No.
Okay. That can be taken down. Next document is CTH.3009.0026.1240_R, Exhibit 1658. Now, there's a number of this is a bundle comprising a number of documents.
Oh, yeah.
Now, you can see it's addressed to the Secretary.
Yep.
Through yourself, then as Deputy Secretary.
Yep.
Says for briefing with me, for meeting with ACOS, 16 August 2017.
Yep.
You know what ACOS is?
Yeah, Australian Council of Social Services. It's a lobby group.
Right. And you understood that ACOS had a particular interest in the Robodebt program?
Oh, yeah, yeah. They were, they're a lobby group. They're interested.
And they were active in making public statements about that program?
Oh, yeah, yeah, definitely. Yep. They wanted it shut down.
Yes. Now, you can see, first bullet point, on the 29th of May 2017, there's reference to a letter from the CEO of ACOS
Yep.
to the Minister.
Mhm.
The Minister at that time was Mr Tudge, correct?
That would be right, yep.
And it refers to attachment A. That document is ten pages in, if that letter can be brought up. It's the 10th page in the bundle. It's got the last 4 digits as 1249. All right, you see that's a letter from the ACOS
Yep.
to Mr Tudge,
Mm-hmm.
29 May 2017.
Yep.
You can see in the first paragraph,
Yep.
reference to the Online Compliance Intervention Program,
Yep.
otherwise known as Robodebt.
Mm-hmm.
An assertion that the program continues to issue inaccurate debt notices, place the onus of proof onto current and former income support recipients, and detect and calculate debts without human involvement.
Mm-hmm.
For these reasons, we reiterate our call for you to immediately halt the program and meet with Social Security experts outside of government to redesign a system of fair and humane debt recovery. See that?
Yep.
All right. If we go back to the talking points at page with the last 4 digits, 1242, and I call out in particular third bullet point. See those words? The government position supported by the Commonwealth Ombudsman is that it is appropriate to ask people for information when there are differences between their Centrelink payment details and Australian Taxation Office records.
Yep.
I suggest that's a reference back to the Ombudsman report from April 2017,
Yeah, that's right.
and it's relying on that report in support of the position.
It's using that report to boost that position,
Yes.
government's position. So the government, the sentence works without the Ombudsman's office, but it's stronger with it.
And then if we go to the letter signed by Mr Tudge, last 4 digits, 1248. Call out, please, the 4th paragraph. No, the next paragraph, please. Now, just to be clear, you agree this is the letter that was signed by Mr Tudge?
Oh, it looks like it. Yep. Yep.
In response to, sorry, if we just bring that down, just call out the first paragraph. This is in response to the letter from Ms Goldie.
This is earlier. Yeah. Yep. So I think the meeting's happening after this letter's gone back, isn't it?
Yes, that's right.
Yeah. Yeah. Yeah.
But the letter that's being referred to is the letter of the 29th of May.
Yeah.
That's the letter that I...
Yeah. Okay. Yep. Yep.
Okay. Now we call out that 4th paragraph again, commencing the Commonwealth Ombudsman's report. It says the Commonwealth Ombudsman's report into the online system found it calculates debts accurately based on the information when the decision is made that is entirely reasonable and appropriate in asking recipients to explain discrepancies in data, and the method of data matching has not changed in approach for many years.
Yep.
And you'd agree that, again, this is an example of that tactic you described before of using the Ombudsman's report to bolster media and bolster statements with media and other public entities.
Yeah. It's to counter the negative press. Yep.
Thank you. That can be taken down. Next document is CTH.3005.0009.5190_R. Exhibit number is 1652. just call out the top of that page in the first paragraph. Do you recognise this document, Mr.
Yeah, this is an application.
What's
Didn't
an
do me much
application
good. It's an application for Treasury Deputy position.
Right. And that's what's reflective of the words. I would welcome the opportunity to take on a role as Deputy Secretary in the Treasury. Such
Yep.
a role would continue to provide me with the wonderful opportunity that I currently enjoy to make an important difference to the people of Australia through delivering on public policy priorities.
That's right.
Can we call out, please, the third paragraph on this screen?
Yep.
All right. Now you see there it says, I'm calm in a crisis. This provides leadership to a range of people, but especially my fellow SES leaders.
Yep.
I was called into the centre of Robodebt. I established a division from nothing to put the compliance budget measures worth $5 billion back on track. At the same time, I shaped the Ombudsman report.
Mm-hmm.
What were you referring to by these words, I shaped the Ombudsman report?
Well, one of the SES criteria is influencing and communicating with influencing. So, that's what you're trying to address in that, is to be able to say that I was able to successfully influence independent decision maker. It's important, like the Ombudsman, the Auditor General, these people don't necessarily take a lot of feedback, so I'm trying to say I was able to successfully influence them.
To shape their report.
Yeah, because normally most of those independent people will reject things, and I think I was able to use my skills to influence that in terms of my intellect and my knowledge to change their minds.
Right. That can be taken down.
Can I just ask about the last sentence, though? And I can tell you what it was, that you'd spent the time in these locations building up the workforce who'd
Yep.
been severely damaged by these events.
Yep.
What was that about?
Well, the staff had a terrible time out of the press, and in terms of implementing OCI, the staff were severely damaged by all the negative press out of what had happened in 2016. So, compliance officers are a fairly dedicated bunch, and so they took it quite hard, the negative press.
It wasn't the actual experience of administering the program?
Oh, the combination thereof. So they probably felt OCI was done to them rather than with them. It wasn't a co-design process like we went to later on. Yes, they obviously have to take the negative phone calls from customers as a result. And then, they're going off to the barbecue and someone's saying, where do you work? And, so it's not an easy job, what they do. And what we did in 2016 did not make their job easier.
All right, thank you.
Commissioner, I'm moving on to another topic.
All right. Do you want to come back a bit earlier or
Sure.
2:15? Okay, thank you. 2:15.
All rise. The Commission stands adjourned until 2:15. The Royal Commission is now in session. Please be seated.
Mr Scott.
Commissioner. Mr McNamara, I'm going to ask you some questions about the engagement of PricewaterhouseCoopers by the department in the first part of 2017.
Yep.
Paragraph 130 of your statement, you state that Secretary Campbell told you she had engaged PwC, PricewaterhouseCoopers, to work on the income compliance program.
Yep.
The Secretary asked me, being you, to work with PwC. Recall saying that at paragraph 130 of your statement?
Yep.
And you note that you were involved in the process to procure PwC services,
That's right.
and the Secretary approved this procurement on the 9th of February 2017.
Yeah, I found a record to that extent when I was reviewing my documents.
So when you say at paragraph 130 that the Secretary told you she'd engaged with PwC, is that a reference to a conversation had between you and her before the 9th of February 2017?
Yeah, it was.
Do you remember when before the 9th of February that conversation happened?
No, I don't.
Whether it was in February or January?
No, I don't. I don't remember.
Beyond just telling you she had engaged PwC, what else was the subject of that conversation?
I think the conversation was she'd engaged one of the senior partners. She talked to one of the senior partners, and he'll be in touch, and you should look to work with them on the program. They're here to help, basically. I've got you some help type aspect was essentially her tone.
Did she elaborate on what she meant by help?
I don't recall the conversation, so no, I probably can't give you any detail on that.
Do you recall whether she indicated what the object of the engagement by PricewaterhouseCoopers was?
I don't know if she said this before that point or after the point, but PwC, I think, was one of, well, won't talk for Catherine, but I think the concept was the Minister had lost a bit of confidence in our advice on strategic matters, especially obviously to do with the program, and PwC was going to come in and help work with us on that. And throughout 2017, whenever we referred to strategy type documents, we were always saying, and this had come from PwC rather than DHS. So I think it was a case of they were going to be more credible in terms of strategy than the department.
Do you mean when you were talking to the Minister you referred to them?
Yes, and to Cabinet.
Do you have a recollection that in February 2017, the program was not performing well in terms of meeting targeted savings?
Oh yeah, the program was effectively paused at this point in time.
Right, but not just paused, it was not, up to that point, it was not meeting its targets.
No, it wasn't. It wasn't meeting its targets, and it was paused. It wasn't functional.
And did you have an understanding that one of the aspects in relation to which PwC was to assist the program meet its targets?
Yeah, it was. Yep, that was one of their key objectives, was to essentially reshape the delivery in terms of number of reviews so that we could meet our targets.
And that is,
yep.
And when you say targets, that is not just reviews completed, but also the end result of that process, which is debts recovered.
Yes, savings as estimated and as provided to government, yep.
did you have any understanding that PwC was engaged to examine the fundamental underpinnings of the program?
No, that wasn't really their role. Their role was a bit more, here's the broad numbers of reviews, here's the savings, here's the assumptions underlying those savings. Essentially what they were doing was a recosting exercise of what about if we move the reviews around, what would it look like?
What do you mean by recosting exercise?
So if you like, the measures have been announced as a series of reviews per year based on different data, and that wasn't going to be achieved. So they were sort of essentially recutting that again for the government.
I'm sorry, what does recutting it mean?
Oh, well, there's a schedule, if you like, of when the reviews are supposed to happen. And they are essentially saying, let's change that schedule because we're not going to meet it. We're not meeting it. What would a new schedule look like?
Right. They weren't engaged to look at the fairness of the program?
No.
They weren't engaged to look at whether or not there were any problems with the use of income averaging to calculate debts?
No.
Can I just ask a couple of expressions that you use in those paragraphs that you were referred to?
Yep.
You say that PwC identified that the agency did not have end-to-end documentation of the business process for the income compliance program. What do you mean?
So if you think about a compliance process from the moment data matching happens to the endpoint where a debt's raised, all those steps, including all the micro steps that a compliance officer would take in debt raising, we didn't have that in one document. We would normally have those things in a flow chart, like debt raising's an A3 that's 220 steps. We would normally have that. We did not have that for this new program.
And then you say there were significant inconsistencies from key staff in terms of their understanding of the process. This is because it wasn't documented, or?
Well, yes, I think that's part of it. And it also goes to the culture and compliance division at the time.
What does that mean?
Well, they didn't talk to each other a lot. It wasn't a great communicative. It was sort of, I'm in my silo and I won't worry about the silo next to me. So I do data matching. I don't do allocation of work to compliance officers. So each EL2 had a team. They were doing a step in the process. And when you went and asked the EL2, what do you do in the process? They tell you. And you'd say, what happened before you? What happens after you in the process? And I'd say generally they didn't have a very good understanding what the next person in the chain was doing or what the person in the chain before them was doing.
Okay, so when you say that the ICT team had the most complete understanding, but that was incomplete, is that what you're talking about, that they don't know what comes before or after?
Yeah.
I see. Thank you for that.
Can I just ask a question as to why it was thought necessary to engage an external consultant to document the department's own processes?
Because we didn't have it, and I'd say at the time when we're talking about here, we're still in this crisis mode, and so we were just looking for someone else to assist in doing that. And again, I think it's this it's this thing of the compliance division is not up to it. So normally you'd ask the compliance division to outline their own business process, but at the moment there's a lack. At this point in time, there's a lack of confidence in that division.
And why weren't they up to it, do you think?
I think there's a bit of a lack of culture. Their culture is not quite what it needs to be.
And can you explain that too?
Okay, so they're not open to different perspectives, and they're not great at communicating with each other. It's a pretty hierarchical, and it's quite a siloed type of environment. So that's an issue at this time. And a couple of the key people, Scott Britton had moved on I think he took Jason Ryan with him very shortly after. They only had a very small team that was actually doing the central work, and basically they dismantled that team about December, January. So they didn't have a lot of corporate memory, was what we'd say in an APS sense. They didn't have a lot of people there who'd been working on this for a while, and there was a lot of, just a lot of angst about what they were doing and how they'd done it. They were
Might the
also-
team get dismantled at that point?
Well, I think the issue, Commissioner, at that point was people had lost confidence in their ability to continue to do the job.
Okay, were you aware of a view that the number of initiations in September was much too great for the stage at which the testing had got? I mean, they hadn't done very much in terms of testing this program as an online program, and then suddenly there are something like 90,000 initiations. Did you know about that?
No, I didn't know about that.
Okay, so you didn't have any perspective on that angle?
Other than the program wasn't working very well, I had a pretty clear idea once I come in that it wasn't working very well and it wasn't very well designed. So that was my perspective in early 2017.
And the design problems, what are you thinking of there?
Oh, well, it wasn't going to scale. They were scaling a process that might work for, see, generally they were doing 20,000 reviews a year where 99.6% of people had a debt, and that everyone they were engaged with had a debt. And you can have a particular attitude and a particular style and a particular business process because it's always going to end up in a debt. This program, only 80% of people were going to have a debt. So 20% of the people you were going to engage in this audit process haven't done anything wrong and aren't going to get a debt. You had to have a different business process. And you're asking people to go back 7 years, which you normally wouldn't have done. You need a different business process. You need a customer-centric business process.
Okay, thank you.
Thank you, Commissioner. Can I just ask a couple of questions flowing from that?
Yep.
Mr. McNamara, you mentioned that under the old process, there was an engagement with about 20,000 people a year, and about 99.6% of people out of that cohort would have a debt, or would be expected that they would have a debt.
Yep.
Whereas you said about 80% of people would have a debt under the new process.
Yep.
Is that a reference to this, that under the old scheme, because you're only targeting 20,000 people a year,
Yep.
and you're focusing on people who statistically have a much higher chance of having a debt, that the likelihood that you're targeting the correct people is higher than if you target a much larger cohort of people?
Yes.
And you're necessarily going to be targeting people where there's a lower chance of there being a debt.
Yes, relative to history, yes, that's right.
And also because necessarily to increase the number of people that you're targeting, you have to take in people beyond that 20,000, which were the highest chance of having a debt.
Yeah, that's right.
And we're talking about an order of magnitude increase in the number of debts being raised, aren't we?
Oh yes, this has gone from a boutique, small, slow program to mass production.
Yes. So the fact that the process didn't change on the department's position
Yep.
isn't actually a good thing, because you're using a process that could only work, if it worked at all, for very high risk cases.
That's right. That's exactly right.
And applying that same process for cases where there's an order of magnitude greater risk that they don't owe a debt.
That's right.
And it was therefore completely inappropriate to scale that previous process.
That's right.
Where did the 80% figure you mentioned earlier come from in relation to the cohort that was targeted under the new process?
So under the new processes, there was assumptions in terms of how many people we would review and how many of them would actually have a debt. And the assumption, different data sets that of the measure had different assumptions, but generally it was about 85% of reviews were expected to deliver a debt.
Were you involved in the calculation, in the development of those assumptions?
Not originally, no. Only for the last measure, the end of 2017 measure, I was involved in those assumptions, but all of that happened before I arrived.
So you have some knowledge of how the assumptions were arrived at
Yes,
in the later period?
yes, and I have knowledge. That's I involved myself a lot in trying to understand what we'd promised and what was underlying the figures.
Right, and so when you say you have an understanding of the assumptions that were formulated for the later period, you're talking about the QP program?
Yeah, well, actually more that what tended to happen from 2017 onwards was at each budget update, whether it was my EFO or budget, we would prepare a cabinet submission which would essentially update these numbers in terms of, and we were never going to get the original numbers in terms of totals, so we'd always go back to cabinet and say, we said we were going to do 600,000 reviews, we're actually going to do 300,000. And we said there was going to be 85% of the people we would review have a debt. Now we're going to say 75 are going to have a debt.
So there's a variance between 85% and 75%.
Yep.
So there's an element of judgment that's being applied to arrive at those assumptions, is that right?
That's right, that's right. So, and in a budget sense, that's an estimates variation. It's a common thing in program world.
Right, and does that require some assessment or judgment as to the probability that the recipients have a debt?
That's right, that's right.
Right, and how is that assessment of probability undertaken for the purpose of these assumptions?
Well, essentially, we had the data to date on what was actually coming in the door. So we could look at the reviews we've started, how many were actually leading to a debt, how many weren't. So we could look at year to date, and then later on into 2018, we developed a predictive model to actually prioritise the reviews, and that is also a model we can use to underline the assumptions, because it's telling us, well, of all these reviews, this is how many we think you'll actually get a debt out of.
Was the predictive model documented?
I think it was, yep, I think.
Is that the term to describe it?
What was our term? No, it hasn't come to me, but there is a term, you find it in the board papers, there is a term we used and the team, I can't remember the term, but there was a term the data team had come up with to, we used it in case selection, this model.
Board papers, you're referring to the Compliance Modernisation Program Board?
Yeah, that's right.
Okay. And
Sorry, I just want to ask this. Presumably the figure that you arrive at, the sort of 75 to 85%, factors in cases where people don't respond and an averaged figure is arrived at to say they have a debt.
Yeah, but this is more based on, given the information we've got in front of us, what's the likelihood that that information would lead to a debt or would be able to be explained by the customer. So that's what the models, and it's a learning model, so the more reviews you do, the more the model learns.
All right, thank you.
But the reality was that throughout the program, more than half of the customers who were sent a letter either did not respond or did not complete the review process.
That's right, and yes, that's true.
So in terms of the learning process that you're referring to, did that learning process work in an assumption that persons that either didn't respond or didn't complete the review process had a debt correctly calculated?
Well, we would have thought all those debts were correctly calculated. No, it's probably beyond my knowledge to give you the detail on that actual modelling. People who work for me would know the detail. I wouldn't have the detail on that model.
All right. Could this document please be brought up? PWC.1007.1001.0009_R, Exhibit 1664. Now, Mr. McNamara, you can see that's a letter addressed to you on PwC letterhead,
Yep,
dated the 6th of February 2017.
yep.
It says, Proposed Services Business Improvement Review. See that?
Yes, yes.
Now, you recognise that language, Proposed Services Business Process Improvement Review,
Yep.
and you recognise this document as effectively the terms of engagement that were proposed for the PwC engagement.
Yeah, it's a sort of standard procurement process for people who are already on panels. We'd invite them to submit a proposal, and this is essentially PwC submitting their proposal.
Yeah. Now, it's dated the 6th of February 2017.
Yep.
Which predates the approval,
Yep.
As you mentioned in your statement, on the 9th of February.
Yep.
So do you accept that this is a draft?
Well, no. So the process would be that they would provide us with this type of document. We'd then assess the document and then go, yes, we accept it, or we reject it, or we ask for changes. So that's a normal part of the process. They say, this is what we're going to do, and then we make an assessment of it.
And you provide feedback on the document?
We could. You know, it's not unusual. Consultants can sometimes oversell, and you'd go back and say, no, we don't want that. We want this. We might want particular people involved in terms of their price, etc. So yeah, so it's an interactive process.
Right, but it would not be unusual for a document of this kind to be after that feedback process you described for modification of this type of document before it's finalised.
Yeah, that's right.
Okay. Can I just call out the opening words on the first line, further to the discussion on Thursday, 2 February?
Yep.
Do you have any recollection of a discussion on Thursday, the 2nd of February, with representatives of PricewaterhouseCoopers?
No, I don't have any recollection.
Okay. Do you have any recollection at all of discussion with PricewaterhouseCoopers prior to them issuing their terms of engagement to you?
No, I don't have any recollection, but I'm assuming from the letter and the things I've reviewed that I did discuss it with them, what we were after, and what, you know, it typically with consultants in this type of process, you'd say to them, this is the type of thing we're after, and they'd go away and work up what they could actually give you or what they could actually do.
Okay. Can I just then call out this paragraph under the heading background? You see that recent high-profile events have accelerated the need to have a detailed and holistic analysis undertaken in relation to the compliance and debt establishment activities of Centrelink.
Yep.
And in the next paragraph, we could call that out. See, it says to do so, you are seeking a clear understanding and documentation of the processes supporting debt establishment and compliance.
Yep.
See that?
Yep.
If we could then go, please, to page 8. First bullet point under the heading limitation and assumptions. It says, we have made the following assumptions when scoping and costing this engagement. It says, the scope of this engagement is limited to DHS's debt identification and recovery processes.
Mm-hmm.
See that?
Yep.
All right. That document can be taken down. Then if we could please have up document CTH.3001.0035.6372_R exhibit 1638. Now, can you see, Mr. McNamara, that purports to be a document headed Agenda and Discussion Topics.
Yep.
And you can see a stamp at the top right-hand corner, received 9 February 2017, Secretary.
Yep.
And you can see in the attendee section, listed is Secretary, Miss Melissa Golightly, and yourself.
Yep.
And then the date, 9 February, 1:30 PM is below that.
Yep.
And meeting subject is indicated, Business Process Improvement Review of Customer Compliance Management Processes.
That's right. Yep.
If we go over the next page, you recognise this document, of course,
Yeah, that's the document I had up before. Yep.
but it's got a different date.
Okay.
It's got the 8th of February 2017.
Ah, yes. Yep. That's changed. Yep.
Now, if I just call out the section under the heading Background again, can you see that no longer has the words, recent high-profile events have accelerated the need to have a detailed and holistic analysis undertaken in relation to the compliance and debt establishment activities?
Yep.
And if we call out the next paragraph, you see the words debt establishment are now gone.
Yep.
And then if we go to page 10, first bullet point, should be 10, yes, thank you. Yes. And you can see the words, the scope of this engagement is limited to, but the words debt identification are gone.
Yep.
Thank you. Do you recall what happened between the 6 February version of this document and the 8 February version of this document that led to those changes that we've just identified?
Not really. No. A long time ago.
No discussion with PricewaterhouseCoopers?
I assume we would have at this time, yeah. But I don't recall anything, but if the documents changed, well, we're likely to have a discussion. I mean, one of the things with these documents is the consultants have a go at it first, and we've probably narrowed it down in terms of what we want out of them.
Yes.
That's what we've done. So we don't have unlimited finances, and so they've said we can do all this for you, and we've obviously gone through a bit of a process to say, how about you do a bit less?
Well, you'd agree, wouldn't you, that one aspect of DHS's debt identification and debt establishment activities at the time of this, the terms of this engagement, involved the use of income averaging as part of the Robodebt scheme?
Yeah. Yep.
And that was the subject of some controversy, as we've discussed in the media at the time.
Yeah, yep.
Can we take it from those amendments that there was a explicit request from DHS to remove the reference to debt establishment and debt identification activities to ensure that PwC would not look at such activities in its reviews such as income averaging?
Well, I think this is just the documentation catching up with the discussions we would have had, but all along what we wanted out of PwC was a new strategy as one output, and we wanted the document of business process. Are the two things we want. All the stuff's just words around that. That's what we wanted out of it.
And you wanted to make it clear that they weren't looking broader than that,
No, they weren't doing other things. No, that's right.
like examining debt identification and debt establishment by the department.
Yeah, we didn't think there was an issue there. What we knew there was an issue with was with the end-to-end business process, and we knew the minister needed further advice on the strategy for delivery of the measures.
Okay. Can we go back to the first page, which is the document with the last four digits, 6372. And call out the first bullet point and sorry, before we do that, if we can just call out the handwriting at the top right-hand corner of that document. You see it says there, agreed, need to proceed on next measure. See that?
Yep,
Is that Catherine Campbell's signature?
that is Catherine Campbell's signature.
Right. And can we take it that's her handwriting?
I would assume so.
We just call out the bullet point in the handwriting further down the page, first bullet point. All right, we see first bullet point says the review will analyse, review and document the current state of end-to-end processes of the department's customer compliance management activities, including fraud.
Yep.
And you see those words in handwriting to the right?
Yep.
Do you agree those words say needs to look at human errors we are seeing?
Yep,
And may we take it that's Catherine Campbell's handwriting?
that's right.
Thank you. And can we call out the fourth bullet point on that page and the handwriting adjacent to it? See the fourth bullet point. Says identify and analyse areas for improvement and provide a high-level implementation plan.
Yep,
And you see the handwriting to the right of that?
yep.
And would you agree that the words there are, how will that work for announced measures?
Yep.
What do you understand that to be a reference to?
I think, well, I assume Catherine's just asking what are they actually going to do in terms of the plan? But I don't know.
Okay. But may I take it from your response that you understand that to be Ms Campbell's handwriting?
Yeah. That's what I would have thought. I mean, identify areas for improvement and provide the high-level implementation plan. That's essentially the main thing they were doing, as I said, for that cabinet process.
Having seen what you've seen of this document, may we take it that this is the document that evidences Ms Campbell's approval of the terms of PwC's engagement?
Yeah.
That document can be taken down. Could I please have document CTH.3005.000.1240_R, Exhibit 689. Now, can you see there, Mr. McNamara?
Yep.
That document purports to be meeting minutes for the Income Compliance Program Board.
Yep.
Can you tell us what that board is, or was rather?
So at that time, that was the governance board that was oversighting the income compliance program.
Okay. And this is meeting minutes for a meeting on the 3rd of March 2017?
Yep.
And can you see on the list of attendees, you're the second last person listed,
Yes, I am. Yep.
and you're referred to as being from the Audit Division.
Yes, I don't think anyone who was probably writing the minutes could understand what position I held at the time. So yes, they've just put audit division.
Okay, could we go to page 2 of the document? Call out item 3. Can you see there that it's referring to an update provided by you
Yes.
on the PricewaterhouseCoopers review?
Yep.
And this is, of course, recently after they've been engaged,
Yes.
and you're recorded as having informed the board of that.
Yes.
I'm going to ask you a couple of questions about it, and without reading it out aloud, can I just ask you to read the full entry there that's on the screen?
Yep.
Just want to ask you about point 1 under what you said to have noted.
Yeah.
The program needs to be designed with a focus on saving measure, but also needs to consider political issues such as customer experience.
Yep.
What does political issues such as customer experience mean?
Well, it needs to have a customer focus, but it needs to have a process that can withstand public scrutiny and is defensible in a public sense. So, we can't be sending debts to people who don't even know the review existed. That's not defensible in a small p political sense for the agency and or the government.
So is this in reference to the media attention the program was having at the time about the unfairness of the program?
Yeah. And this meeting, for context, this meeting is me going to the board and telling them that OCI is finished. And for context, it wasn't a very pleasant meeting.
Right. But may we take it that those issues about the fairness of the program you saw as a political issue?
Yeah. So, I saw that as it's a small p political issue, but I think the attitude and compliance that came across at this meeting and around about that time was this was just a media beat up and we haven't done anything wrong. That was the attitude. So I was trying to say in this meeting and in others that no, it wasn't just a media beat up. This was something we had to fundamentally change.
And would it be right to say that the reason why you thought it to be a political issue was that if those media issues were not addressed, that was a risk to the continued support by the government of the program?
That's right. Yes, definitely. Definitely. They weren't going to continue to support us, no matter how many savings are involved, if you were running a poor program.
But of course, what this note acknowledges is the fundamental tension between those political issues and the need for the program to achieve its budgeted savings.
Yeah, and that's that was my job. How do you transform the program to do the dual thing of being customer centric and deliver the savings?
that document can be taken down. Could the witness please be shown document CTH dot 0019 dot 0001 dot 0073, exhibit 1688. See, Mr. McNamara, that purports to be a brief to the Minister for Human Services for action. Just look under.
Yep.
See that?
Yep.
Thank you. And if we go to the third page, which is the doc ID 0075, purports to be signed by you, although your signature has been redacted.
Yep.
And the date of the document is the 23rd of March 2017.
That's right. Yep.
You just go back to the first page.
Mm-hmm.
First point under the key points. PwC and Data 61 have made a number of recommendations to change aspects of the EIC.
Yep.
We've talked about PwC already, but who's Data 61?
So Data 61 is the CSIRO's commercial consultancy arm, and they were brought in to help with case selection, to improve case selection. So it was either Ms Campbell or Minister Tudge's idea that we should bring in Data 61 to increase the expertise.
What was the purpose of involving them for improving case selection?
Well, yeah, the issue of we want to choose the people with the highest probability of having a debt, not the people with the least probability.
And was the relevance of that, what was the relevance of that?
Well, the relevance of that was that twofold. One is it's an efficiency issue. We don't want to spend time. It's a customer-centric type issue because we don't want to put people through a review if they don't need to unnecessarily. So that was the sort of two dual aspects of what they were doing.
Right, okay. Well, if we can just call out point 2, which goes over the page. So that's subparagraphs A and B, and also points Roman numerals 2 and 3 below. Now you can see that the first point is that Data 61 has recommended a complex machine learning methodology. This will take some months to build. And there is some risk that such a methodology may not be possible given the data quality.
Yep.
And given that it was going to take some months to build, the point is made in the second subparagraph B that in the interim, PwC has recommended a revised methodology. You see that?
Yeah, yep.
That prioritises the selection of cases based on the likelihood of recipients having a debt.
Yep.
And what was the significance of this interim measure that was proposed?
Oh, well, at this stage, everyone thought that we could get the measures back on track, and this was essentially the path to getting them back on track, consistent with what had been announced in the budget papers. So this was just them saying, this is how you can, when they had sort of spreadsheets, this is how you could get back to business as usual and deliver by the end point what you promised the government to do.
Okay. If we go then to call out point 3, it says PwC has suggested we implement a number of further improvements to the EIC system progressively from April 2017. See that?
Yep.
And of course, because it's using the language EIC, is this right? the scheme was transitioning into ERC.
Yeah. OCI was essentially stopped, and we were at this stage we hadn't turned EIC on, but yeah, we were developing EIC.
What I'm interested in is point A in particular.
Yeah.
It says, our experience to date from the revised process from February is that all applications are being completed manually with a compliance officer.
Yep.
Some of the recipient are coming offline for very simple questions.
Yep.
We intend to put these recipients with simple queries back into the online system.
Yep.
Now, is the reference to the revised process from February a reference to revisions to the process in early 2017 in which the initial letters had a phone number put on them?
Yeah, it does, but this is probably more referring to the new way that we did EIC, where at a design principle, every time someone had an issue, we essentially stopped the online process and essentially forced them to ring us instead and not continue. So if anyone had a query, a question, the online system was all directed at that stage to say, stop, come into the manual system, call us please instead.
I see. So there were changes to the online platform.
Yep.
That recipients were directed to by the initial letters.
Yep.
What the platform indicated was if there was a question that the recipient had in completing the process online,
Yep.
the platform would direct them to call the Centrelink office.
And that's right. And at that time, we hadn't, EIC hadn't been built with an ability to put them back in line. So they might have a very simple query, how do I treat allowances or something? This compliance officer could answer it. They actually couldn't go back online then. So some people would say, oh, thanks for that, can I go back online? And it's like, no, you can't. You've got to stay with me and complete the review on the phone. So we had to do more coding, more changes to be able to allow people to go back online.
And it was essential that they did go back online for the success of the program, wasn't it?
Well, at this time we thought so, but yeah, at this time we thought so, but subsequently we were, by the end of 2017, we're running the program reasonably successfully in a manual way, and we're not having people, the online system's there, but it's not being utilised by many people, and it's essentially become a customer compliance in terms of staff. It's become a staff-driven system, not an online-driven system.
So by the end of 2017,
Yep.
virtually all social security recipients who received these letters
Yep.
completed the review process manually.
Yeah, that's right. It's not until CUPE comes along the year after that we start to see an uptick in people completing online.
But obviously, if the vast majority of recipients aren't completing the process online and they're completing them by interactions with a Centrelink staff member,
Yeah.
that's going to be a time-consuming exercise.
Yeah, and you know, we had to get just over another 1,000 staff. We asked the government for over 1,000 staff to run the program extra. So we originally had 400, and by this time, later on in this year, we moved to a situation where we have 1,450 staff working on the system.
Right. Did that have a correlation with whether or not the program was meeting its targets in 2017?
Oh, the program never meets its targets at any stage relative to what was originally announced.
It didn't come close to it, did it?
No, it didn't come close. I mean, the final year we overachieved what the revised targets were being to government. We were up to about 8,000 reviews a week being completed. But I think our aim was to get to 10,000 reviews a week at that time. So 8,000 wasn't too bad. And it was double productivity 17, 18 to 18, 19. We basically doubled productivity in the program.
Just while Mr Scott's looking for something, the 1,000 extra, was this the labour hire force that was brought in?
Yeah, there was agreement by the government to give us 1,000 extra people, and then there was a cabinet process, and out of that came the fact that they had to be labour hire.
Why'd they have to be labour hire?
Decision of the Prime Minister.
And how well trained were they?
Oh, they were trained as well as our compliance officers. One of the things we did, Commissioner, which was quite unusual at that time, was Mr Storen and I decided that this workforce would come in and work within the compliance division rather than as a separate call centre, smart centre. We'd actually combine it and put these people within. It worked quite well. The issue is this work is not for everyone. So we had a pretty high dropout rate in the training, 7 to 8 weeks training, had a fairly high dropout because once people could see what the work actually was, they were like, yeah, this is not for me. But you know, Mr Storer will be able to give you more information, but it was actually this program and those people have been a major source of recruitment for the agency because you know they came in, they understood the agency, they liked the work, they then became trained up, and a lot of those people moved into the APS permanently.
Thank you. Mr Scott?
Commissioner. That document can be taken down, but could the witness please be shown CTH.3004.0009.0076 Exhibit 1649. Now you see that, I'm jumping ahead a bit, but in light of our discussion earlier, see it purports to be a compliance modernisation program management dashboard.
Yep.
And if we call out the section at the top right says report week ending 22 June 2018.
Yep.
Are you familiar with this kind of document?
Yeah, this was a weekly report that used to be produced in my division.
Sorry?
It was a weekly report that was produced in my division.
Right. And to whom was it provided?
It was definitely provided to the board. I'm not too sure if we gave it to the Minister or his office. I have a vague recollection that we might have given it at the start to Minister Tudge's office, and then he said, Minister Tudge, and he said, just give it to my office instead. So I think it's the type of thing we might have provided up the line.
And not just to Minister Tudge, because of course he wasn't the Minister for Human Services for the duration of the program.
That's right, but you know, some ministers are interested in this level of detail, other ministers are not, and you know, some of them will say, just keep my office in the loop, and this would be the type of document that we can provide.
Would this type of document typically be provided to the other ministers who are the Ministers for Human Services?
They could have been. It wouldn't have gone to Minister Keenan. He wasn't, it might have gone to his office, but it wouldn't have gone, Minister Keenan didn't really get involved in the program, so it wouldn't have gone to him. We may have given it to Minister Roberts' office when he came and was our minister again in 2019. But I don't recall, but this is just a standard management report that we would produce.
Okay. Can we just call out the section at the top left-hand corner headed budget measures? Now, just down the left-hand column,
Yep.
headed total, there's EIM total and NEIDM total. You see that?
Yeah.
Now, is this right? EIM stands for Employment Income Matching.
Yep.
Whereas NEIDM stands for Non-Employment Income Data Matching.
That's right.
And Robodebt scheme's about the EIM, not NEIDM, is that right?
It's about all of it. No, this is all the income compliance program.
Okay.
Well,
Might just take that document down for a tick. And bring up document CTH.3753.0001.0126, exhibit 1613. Now, this is a document that purports to be the Compliance Modernisation Program blueprint.
yep.
And if we just call out section headed Proposed Program Structure. And you see the section Compliance in blue, section Compliance Modernisation Program.
Yep.
And you can see it describes consolidation of all data matching activities and subsequent budget measures under that heading.
Yep.
And you can see it distinguishes between EIM and NEIDM.
Yeah, it does. Yep.
And in respect of EIM, it refers to the budget measures that falls within that program.
Yep.
And it would accord with your recollection that the first of those budget measures that's listed there next to EIM is the 2015-16 budget measure?
It may have been. There's a document in my statement that's probably better to explain the measures if you want to have a chat about what the measures were than this. But in the 2019 brief to Minister Robert, one of the attachments has a nice table that shows you all the measures and how they work that we used to use for ministers. So if you just wanted to go to that. But I'm happy to answer this.
Okay, well, in any event, you accept that there's a number of budget measures that fall under EIM.
Yeah, that's right.
And the first of those was a 2015-16 budget measure.
Yeah, yep.
And then there was a series of MyEFO
Yes,
measures.
that's right.
And then the same happened with respect to NEIDM, correct?
Yeah, so how the measure is actually announced is it's announced by data source, is how I'd put it. Whether it's the PAYG data source or the tax return data source or the asset data source. That's how they announce them.
Yes, and NEIDM didn't involve PAYG data.
That's right. It was the tax return data.
Yes, whereas EIM related to PAYG data from ATO.
That's right.
The averaged PAYG data.
Well, it relates to PAYG data, yeah. Yep.
Okay, well, if we can come back to the document CTH.3004.0009.0076, exhibit 1649 that we were on before, and call out again the section budget measures. You can see the budget column.
Yep.
And is that purporting to describe target savings and target interventions announced for the budget measures that the relevant programs related to?
Yeah, so that's what would be in the budget at the time this document was produced, not necessarily what was announced. What was announced was probably higher. This was probably down a level because we'd gone to Cabinet and revised what we were doing by this time.
Yes. So in other words, this isn't, when it talks about target savings, that's target savings after those targets have been revised after subsequent measures.
Or revised down, actually, but yes.
And that was the case with the Robodebt scheme, wasn't it?
Yeah, so these have been announced, and this is how much is sitting in the budget papers, in the budget estimates at this point in time.
Yeah. So, in other words, target savings announced in the original measures were revised down over the life of the scheme.
Yeah, because originally they were $7.5 billion.
Originally $7.5 billion.
Yeah.
And the reason why they were revised down over the life of the scheme was they were just not meeting those targets.
Oh, they weren't realistic. They weren't realistic. Once we'd actually run the scheme for a while, you could understand that they weren't very good estimates.
Right. And so on the next column, life to date, that's got a section achieve savings.
Yep.
And that's, as you recall, this is at 22nd of June 2018.
Yep.
So some years into the program.
Yep.
And bearing in mind what you said was originally announced for the program, $7 odd billion.
7.5, yeah.
Right. And is this right? As at the 22nd of June 2018, all of the program achieved in savings on this document was a bit over $1 billion.
That's correct.
And when it talks about 30% of the target achieved, that is the revised down target.
Yes, that's right.
Okay, thank you. That document can be taken down. Could the witness please be shown document CTH.0019.0004.0506_R, exhibit 1629. Now you can see this is another brief to the Minister for Human Services for action.
Yep.
If we go to the last page of the document, that is .0507,
Yep.
you can see again it purports to be signed by you, although your signature has been redacted.
Yep.
And it's dated the 22nd of February 2017.
Mm-hmm.
We go to the first page. Just under the heading Key Points, first point. It says, in response to your request and in consultation with you, the department has made a number of changes to the OCI.
Yep.
Point A, we have refined our approach to data matching letters, the online system, and how quickly people are referred to the department.
Yep.
And it refers to changes at attachment A with revised letters at attachment B.
That's right.
Would we be right to take it that changes to the process, including to the letters that were sent to recipients as part of the program, were briefed to the Minister?
Oh, yes, yes. Yes, definitely.
And why is that?
Like the new letters,
Why were they briefed to the Minister?
why were they provided to the Minister?
Yes.
Well, so the process of revising the letters, Mr. Scott, was that my recollection is Ms. Campbell and Minister Tudge rewrote the OCI letter together and provided it to me. I then had it user tested, and I I informed Secretary Campbell that after user testing, we'd kept the signature block, and the rest of her letter and Minister Tudge's letter had been removed and replaced with different words. So that was the process. So as a result, we wanted to put back in writing to the Minister that we actually had changed it, and what he had essentially worked on, we weren't using.
Why is that?
Because it didn't user test very well. So we had a user testing with customers, and language, understandability, etc., didn't work. And so what we do in user testing is we work with the customer to try and, we know what we're trying to get across in terms of a paragraph, and then we're working with the customer to see what words they understand and how they would interpret what we're writing. You know, that's how you do the process. This was quite good because Minister Tudge not only agreed that the letter he'd worked on wasn't going to be the one we sent, but he actually, I think it's this minute when he signed it, or one very similar, where he wrote on it, I want every letter that goes out of the department to more than 10,000 people to go through this process from now on.
Was that the user testing process?
User testing. And it was actually the catalyst for why now we just use user testing in the agency as a standard thing when we're doing any communication product, but especially.
Was this the first time you'd done it?
No, I wouldn't say it's the first time we've done it, but this was definitely a different level.
Had there been any user testing for the OCR letters?
I understood there was, but you can do user testing and ignore what people tell you to, is how I sort of frame that. So you can, people can say, I found that confusing, and you can write in the report, I found that confusing, and just keep going.
Mm-hmm. And did you think that had happened, I suppose, is the obvious next question?
A couple of the stories I heard were that from the people who were there in OCI was that they had ambitions to do better, but there was ICT constraints in doing a better quality letter. So they didn't do what they set out to do.
Just on the subject of user testing, can the witness please be shown document CTH.300.0001.8801_R, Exhibit 1680. Now you see that's an email headed CMP board papers.
Yep.
28 March 2019.
Yep.
So just to orient things, this is at the time of the QP program, CUPI.
That's right, yep.
And if we just call out the agenda item 6.1, see that it says the item is referred to as QP update on flyers.
Yep.
And there's a reference to QP letter.
Yep.
Current, revised.
Yep.
Flyer, and user testing report.
Yep.
And would this be right? This is in the context where on the recommendation of the Ombudsman, the department was testing ways to better explain the concept of averaging to customers.
That's right, yeah, and it was quite a difficult process.
So that customers would know that if they didn't respond to the letters, the ATO data would be averaged across each fortnight that the period under consideration
That's right.
would apply.
Yeah, that's right.
And would this be right, that this was the first time there'd been any testing of ways in which to communicate the concept of averaging to customers?
Yeah, I'm pretty sure that probably would have been the main time we tested that.
Okay.
Trying to explain it. So the QP original letter tells you that we're going to apply the tax office data, but doesn't try and explain it to you, where this is trying to explain how averaging works.
Well, if we look at document ID CTH.3004.001.8827, exhibit 1681. This is an example letter. See that?
Mm-hmm.
Purports to be to a hypothetical Mr. John Jones, you see?
Yep.
It opens in the first sentence, we need to make sure that you receive the right amount of payments from us in the past.
Yep.
And then the second, it says the Australian taxation officers have given us information about how much income you earned from work in the past.
Yep.
And the third paragraph, the information from the ATO is different to the information you reported to us.
Yep.
See that?
Yep.
And then we go to the second last sentence on the page. If you don't check and update your information, we will use the details we already have, including the information from the ATO. This might mean you have to pay money back.
Yes.
And then if we go over the page, see the heading past income information?
Yep.
And then there's a grey box referring to 3 hypothetical employers.
Yep.
Detailing dates of employment.
Yep.
Earnings from those employers over those dates.
Yep.
And of course, the letter, you'd agree. And we can show you the last page if you want as well, but you'd agree that these letters did not themselves indicate how the data obtained from the ATO was going to be used for the calculation of debts.
No, we didn't. We didn't have it in there, and that's why we were developing the flyer to provide that additional information. I think we had stuff on our website, but we were going to include a flyer that actually explained averaging.
And then if we go, please, to document ID CTH.3004.0011.8833, exhibit 1683. Is this the proposed flyer?
Well, if you've got it out, that'll be the proposed flyer. It's so long ago since I've seen it, yeah.
Okay, well, if we call out, see that the shaded box in the middle of the page?
Yeah.
Call out the second and third bullet points.
Yep.
We'll divide the ATO amount by the number of fortnights you work. This will give us an average of your earnings for this time.
Yep.
However, the hours you worked or the amounts you earn change each fortnight. You need to tell us, including the exact amounts, using your pay slips or bank statements.
Yep.
You recall, this is what purported to be the explanation of averaging in the flyer.
Well, we were trying. We found it really difficult in the user testing for people to understand what an average is. So the customers we were testing this with did not understand the mathematical concept of an average.
Yes.
And so this was actually really quite difficult, trying to explain averaging to people when they didn't understand what an average was.
Well, could we bring up CTH.3004.0011.8835, exhibit 1684? Do you recognise that document?
Yeah, no, it's the user feedback. Yep. No.
This is the report of the user testing.
Yeah, this is one of the user testing reports. Yep.
All right, if we go to page 1 of that document, last 4 digits are 8836. And you can see under the heading background,
Yep.
user testing was held from 19 to 21 November 2018.
Yep.
There were 15 interviews conducted in total across 3 locations.
Yep.
You recall that was 15 interviews, that is with 15 different social security recipients.
Yeah.
Okay. And then if we go to page 2, sorry, before we go to page 2, we go to the heading on page 1, products tested. It says there were 5 products in total tested for this round of user testing. A revised initiation letter.
Yep.
That is proposed variation to the then current QP initiation letter.
Yep.
The flyer, which we've just discussed.
Yep.
And then the current QP initiation letter.
Yep.
Okay. So if we go to page 2, call out the section at the bottom headed revised initiation letter. First bullet point says 11 of the 15 participants read through the letter first after opening the letter, envelope I should say. 11 participants were able to identify how long they had to take action. And then last bullet point, 14 participants were able to demonstrate a basic understanding of what the letter was telling them.
Yep. So that's important. So one of the things we do is we say, what do you understand from this letter? And if they can come back to us with a decent explanation, that's a real positive for us.
Okay, then we go to page 3, please. Call out the first bullet point on page 3, the top of the page. It says 13 participants were not able to explain correctly in their own words what would happen if they did not provide the information requested within the letter.
Yep.
This was testing for the comprehension of the averaging paragraph.
Yep.
11 participants thought that their payments would either be suspended, cancelled or otherwise affected in some way.
Yep.
Words like, I will lose Centrelink payments and maybe get a legal notice. My pension would stop or reduce. My pay will be deducted.
Yep.
2 participants were less specific with their answers, saying they were going to be in trouble.
Yep.
And then the next bullet point after this one. Only 2 participants of the 15 were able to correctly explain in their own words the concept of averaging and what would happen if they did not provide their correct information to Centrelink.
Yep.
This is telling you that on the proposed revised initiation letter,
Yeah.
that only 2 of the 15 participants tested understood that they were at risk of their entitlements being calculated using income averaging.
Yeah. Yeah. That's right. That's why we test it. So we were testing the letter because the Ombudsman wanted changes in the letter. We didn't really want to change the letter. And the flyer was a compromise. Why don't we put it all on the flyer?
Okay. Then could we go to the next bullet point? It says 8 participants expressed negative feelings after reading the letter. 2 felt that the letter was threatening.
Yep.
Words such as I would be anxious, I would feel that I've done something wrong.
Yep.
Those sorts of words.
Yeah.
Then could we go to the next heading, flyer. In particular, the 3rd bullet point under that heading. And this is dealing with testing in respect of comprehension of averaging
Yep.
after reading the flyer. It says only 3 participants were able to correctly explain in their own words the concept of averaging.
Yep.
However, 2 of the 3 had already shown comprehension of averaging when explaining the letter.
Yep.
So the point that's being made is that even with the flyer, it only had an impact on 1 of the 15 participants.
Yeah, we weren't, the letter didn't test well, the flyer didn't test well.
Then could we go to page 4, please? Heading current initiation letter. Last bullet point. Whilst most participants preferred the revised initiation letter, and sorry, this is dealing with what was then the current letter being used in the CUPE process.
Yeah. That's what, you want to always test the base at the same time.
It says there were still only 2 participants who understood and could articulate the concept of averaging. So what this was telling you was that under the then current process being used for CUPE, on the 28th of March 2019, that recipients of these letters did not understand that they were at risk of having their entitlements calculated on the basis of averaged PAY income data.
Well, I think what we were getting out of this user testing is they didn't understand averaging, so it was hard then to be able to say we're going to average the ATA data for anyone to comprehend what that meant.
Well, that's what I'm saying.
Yeah.
That only 2 participants could understood after reading the then current letter
Yeah.
that they were at risk of their entitlements being calculated on an assumption that they earned their income in equal amounts for each fortnight under consideration.
Yep.
Didn't that tell you that there was a fundamental problem with the program?
Told me there's a fundamental problem with the Australian education system where people can't understand averaging. It's pretty poor that people can't understand adding numbers up and dividing by the weeks actually is an average. That's pretty appalling. But that's where we're at as a society, so there you go. I've still got to communicate with those people. I've still got to explain. This was a very difficult process because we wanted to explain it to people, but essentially it was very difficult to do. It's not a, we sort of had to explain averaging first and then the application of averaging. So I had to do both, not just the application of averaging. And that's pretty difficult for us to do.
But the point of the initiation letters surely was to put customers on notice of what might happen to those customers and their entitlements if they didn't engage with the process.
Yeah, no, that's what we were trying to do. We just hadn't been able to formulate a set of words that people generally could understand when it came to averaging.
And as at the 28th of March 2019, a matter of months from when the Solicitor General's advice was provided and the program was brought to an end,
Yep.
the program was manifestly failing to put recipients on notice of what they were at risk of if they didn't engage in the process.
Well, I think we were giving them that information. It's whether they were able to comprehend it is the issue. So I was telling them what they needed to hear. Were they able to easily comprehend it? No.
But surely the object of these letters was to ensure that they did comprehend.
Yes, but these letters went through an enormous amount of work, especially with the Ombudsman's office. Every Tom, Dick and Harry had a view on different words, but they just didn't work. That's the bottom line. If someone has some better words out there, that would be great, but we couldn't find a set of words where people could understand averaging. That was the problem. And in the end, I moved forward with putting the flyer out, even though it doesn't use a test that well, because I think it's better to put it out there and have at least it allows people to show it to other people and possibly to, have someone else explain it to them or bring it into a service centre and have it explained to them. That was a better outcome than nothing, but I can't overcome the fact that people don't understand the concept of averaging.
You don't think it may have contributed to their difficulty coming to grips with it, that they just didn't get average incomes?
I just don't. I think from the people who were conducting this testing, my staff, they said they didn't understand averaging. It's not the averaging, it's not the application, it's just the averaging. I mean, the social security system is very complex, Commissioner, and I think one of the things we try and do is not subject the customer to the complexity if we can help it. Now, the flip side of that is you're trying to be fair to people and give them their rights and give them an explanation, and people want more explanation, but you've got the other problem of if you give them too much information, you make it too complex, it's actually detrimental to them. So that's the balance we do in behavioural science, that's the balance we do in this user testing.
But you well know that under the Social Security law, the Social Security recipients is generally calculated according to what their actual fortnightly earnings are, aren't you?
With income, yes.
And to a large extent, recipients of Social Security don't earn their income in equal amounts per fortnight.
Well, they may not. I don't know if I have any data to say one way or the other, actually. So,
but intuitively, you must know that for the types of people that are receiving Social Security payments, many of them will not be earning their income in equal amounts. Surely, Mr. McNamara.
not necessarily. If they've got a job, if they've got a job that's a part-time job or a job where the hours are variable, then certainly. But if you've got a normal paying job with normal hours, the pay's going to be pretty standard. So we've done analysis of trying to look at accuracy in this space, and there's quite a number of people who earn a smooth income. It's not unusual. I grant there's lots of people who don't, but it's not like a small number of people have a smooth income either. It's a reasonable amount of people.
But do you understand the point of the legislation calculating entitlements by fortnightly income is a reflection of the fact that many Social Security recipients won't be earning their income in equal amounts per fortnight?
Oh, well, I don't know why the Parliament makes the legislation and the policy the way it does, but that's the policy, yep. They do it on a fortnightly basis.
What about students, Mr. McNamara?
Yep.
Earning on casual hours?
Yep.
They're a frequent recipient of Social Security payments, aren't they?
Yep.
And by definition, casual workers typically have variable amounts of income.
Yeah.
Seasonal workers.
Yeah, seasonal workers, we had a particular issue with teachers. Supply teachers was a particular category of people that struggled with this process. They did the right thing, but nature of the system, they weren't there. And seasonal workers, especially Mr. Storin used to talk to me about people on fishing boats was another chunk of people that, just don't earn in a linear way. Yeah, they don't earn in a smooth way. Yeah, there's lots of people out there like that.
So it's obviously a large assumption to make that in the absence of being told otherwise by the recipient, that they have earned income in equal amounts per fortnight. Yeah. Surely.
We have to estimate their income in the basis of information. This is an estimate of their income.
But surely, if you're going to make that estimation, given the legal requirement to calculate entitlements based on actual fortnightly earnings, that you would at least tell the recipient that they are at risk of those entitlements being calculated in that way.
Well, we are saying that. We are telling them that that's what we're trying to communicate with them, and through both the online system and the education. But, it is still our position at this time that this is a lawful way to estimate their income. So we're trying to explain it to them, but from our perspective at this time, it's a lawful way to estimate income.
Okay. Can I just ask, in relation to your understanding of it being lawful, paragraph 164 163 of your statement on page 32, refer to the interactions and key documents that you recall receiving in connection with the legal position on the sufficiency of evidence to raise a debt outlined below in that statement, if we have the page up. Now, just note, Mr. McNamara, you can see that there's some redactions on this document because there's public interest immunity claims over the parts of it. So I'm not going to ask you to disclose what's behind those redactions, but you can just note the last sentence of paragraph 163.
Yep.
Right. And you refer to some documents you received shortly after first joining the group in January 2017.
That's right.
I just want you to confirm that none of those documents that you refer to receiving in January 2017 deal, I should say, with the lawfulness of income averaging to calculate debts.
No, I would say one of those documents does.
So one of the documents that's referred to in paragraph 166 or 167, again without revealing the contents of those documents?
Yes, one of them is very explicit.
I see. Okay. Commissioner, I note the time. I think the next witness is due. Unfortunately, I think this witness will have to come back in hearing block 3.
All right, it's only 10:02. Is the next witness available? I see Mr. Gregory's there. Do you know? So I don't know, Mr. Scott, is that a good place for you to stop? And you can't finish, I take it?
No, unfortunately, because there's a public interest immunity claim over a document that's just been relied upon by the witness.
All right. Yes, we have run into a bit of a problem there, Mr. McNamara, with the Commonwealth taking that claim and us having some interest in what you were saying about it. I'm afraid we'll have to get you back to help us again in January.
Okay.
Thank you. Mr. Antiotidis?
Could I just have a quick word with counsel assisting?
Sure.
Just excuse me for a minute, Commissioner.
Sure. This one? Camera's out.
Mr. McNamara, without disclosing the contents of any documents that have been redacted in those paragraphs, and could I have that back up on the screen? Can you say, by reference to the paragraph that the document is referred to in paragraphs 165 to 168, which document you're referring to as indicating a position on the lawfulness of income averaging?
I would interpret both 166 and 167, but especially 167.
So the documents that have been referred to but are in passages that have been redacted?
Yeah.
Okay, thank you. I think that
So where are you up to? You still need Mr McNamara back?
I do, yes.
All right. Thanks, Mr McNamara. That's it for the moment.
Okay.
But we will need you back.
Thanks.
I understand a 5-minute adjournment is needed to set up the video call for the next witness, Commissioner.
All right, thank you.
All rise. Commission stands adjourned for a short break. The Royal Commission is now in session. Please be seated.
Yes, Mr Gregory.
Yes, thank you, Commissioner. I appear this afternoon with Mr Freeburn of Council, and the next witness is Melanie Klieve, Klieve. She is on the screen and in a position to take an affirmation.
Yes, thanks. Administer the affirmation.
Your reply is I do. Do you solemnly declare and affirm that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Can I just check, is there to be a non-publication order in relation to Ms Cleeve's identity or no?
No. Can you tell the Commission your full name, please?
Melanie Jane Klieve.
And you are currently living in Broome in Western Australia,
That's correct.
and that's where you're giving evidence from today.
That's correct.
Did you prepare a statement in preparation for giving evidence in this Royal Commission dated 1 December 2022?
Yes.
And in the preparation of your statement, did you have regard to a payslip you obtained from a former employer and also to a range of documents provided by Services Australia in respect of your Centrelink file in 2016 and 2018?
Yes.
Commissioner, I tender the statement of Ms Klieve and a number of related documents, including NTG 0102 to Services Australia, the response, and a number of attachments, including the payslip to which I've referred. There should have been an exhibit list provided. They commence in the draft at Exhibit 1690 and go through to Exhibit 1705.
All right. Ms Cleeve's statement and the other documents to which you refer will be numbered 1690 through to 1705 in accordance with the list in the schedule I've been provided. Thank you.
Thank you. Ms Klieve, can we start back in 2016? Where were you living in 2016?
I was on Kangaroo Island and in Tasmania.
For the first of those places that you lived, that was Kangaroo Island.
That's correct.
And were you working there?
Yes.
And where were you working?
At the oyster farm shop, Kangaroo Island Oyster Farm shop. Prior to that, I don't know, if 2016, I was running my own business as well and working casually at other places. But I think it was predominantly at the oyster farm shop in 2016.
And the nature of your employment at the oyster farm shop, was it casual, permanent part-time, permanent full-time?
I believe I was casual. I might have been full-time, but I think I was casual.
And did your income fluctuate during the period that you worked there?
In the year 2016, I was on regular hours because I was managing the oyster farm shop.
Right.
Prior to that, I was a casual shop assistant, so they did fluctuate.
And did there come a time when you decided that you wished to leave Kangaroo Island and return to Tasmania?
Yes.
And did you have some prior connection with Tasmania?
Yes, I own 2 houses in Tasmania.
No doubt with mortgages?
Yeah, one with a mortgage.
And how long had you been away from Tasmania?
I think it was about, I moved there in 2008. So around 8 years.
That is, moved to Kangaroo Island?
Sorry?
When you say you moved there in 2008?
Oh, yes, to Kangaroo Island.
And was there a particular reason why you moved to Kangaroo Island in 2008?
Yes, my parents are still on Kangaroo Island. I was born and bred on Kangaroo Island. So my mother came to Tassie and asked me to come home. So I went home with my daughter.
Were there some other life events that occurred a little earlier than that as well?
Yes.
And did you find that one of the reasons, as a result of those events, that you moved to Kangaroo Island was because you needed to be close to family in at least an emotional support sense?
That's correct.
And are you a mother?
Yes,
How old is your daughter?
she's 22.
And what prompted your move ultimately back to Kangaroo Island in 2016?
I had some funds from, I can't really say where from, but because it's a confidential agreement on it, but I had some funds in the bank
Yes.
and they were going down quite quickly. And a friend rang me and told me there was a winery for sale in Tasmania. So I decided to go home and put the money that I had into the winery rather than have it all go to expenses on Kangaroo Island, and try and find work there as well. Financially, it was a better option to go back and live in my house as well. I was struggling on Kangaroo Island to pay a mortgage and rent at the same time.
Yes. Now, while you were working at Kangaroo Island, did you claim or receive any Centrelink benefits in 2016?
No, I wasn't eligible for the whole time I was on Kangaroo Island to Centrelink. I was told that because I owned 2 houses in Tasmania, I couldn't claim Centrelink in South Australia.
Now, when you left the oyster farm shop, was that in approximately late November or early December 2016?
Yes, late October, early November. So that last pay slip was my last pay slip. And I moved to Tassie within a week or 2 weeks after that.
Perhaps if we can go to the payslip, it's MJK 999.0001.001. It's exhibit 1693. Can you see that payslip, Ms. Klieve?
I can.
And that records a pay period from 24 October 2016 to 6 November 2016. And it includes a year-to-date column, second from the right in the table at the bottom.
Yes.
You can see that. And the year-to-date figure there is $10,064.25.
That's correct.
All right. Now, did you obtain this payslip in the course of preparing to give your evidence here?
No, I had that payslip in my emails from when I left the oyster farm shop. I was emailed my payslips.
Right, okay. And to your recollection, I appreciate it's some time ago now, was that the last payslip that you received from the oyster farm shop?
Yes, well, it was the last one in my email, so it had to be the last one that I received.
All right, okay. So you left Kangaroo Island and returned to Tasmania. Did you apply for Centrelink after leaving Kangaroo Island?
I did. As soon as I got to Tasmania, I applied for Centrelink.
And were you also looking for work when you returned to Tasmania?
Yes.
Were you able to find any work there?
I did find work. I'm not sure if I found work in that year or subsequent. I've worked a lot of jobs over the years, a lot of jobs in Tasmania since 2016. I know I worked at the bakery in Rosebery for a period of time. They didn't supply me with pay slips, and so I have no idea when that was, but I did report all my earnings from there to Centrelink.
And did you understand that you had an obligation to report your earnings once you applied for and were granted an entitlement to Centrelink payments?
Yes, every time I've been on Centrelink, I've worked and I've reported my earnings to them.
Were you supporting your daughter at this time, Ms. Klieve?
Partially. She was living with my sister in South Australia, and she came with me to Tasmania as a holiday. She was going to go back to South Australia, but she decided to stay in Tasmania and go to school there and do year 11 and 12. So she was on Centrelink payments because she was living down at the school and boarding, so she was getting payments while she was living down there. Any extra expenses, though, I was covering.
And so was it the case that in 2017 she was doing grade 11 in Tasmania?
That's correct.
And she was approximately turned 17 that year.
Yes, in March.
And after returning to Tasmania, did it take a little while for your application for Centrelink to be approved?
It took a long while for my Centrelink application to be approved. It was only approved after I rang them and said my power is going to be cut off tomorrow. I have no money in the bank to pay for anything. And I did that 2 days in a row and they approved it.
And does that mean that the money that you had accumulated or had left in your bank account when you left South Australia was used for living expenses and the return?
That's correct. I'd exhausted all my savings.
The history of your employment, can you just outline the sort of work that you did, say between 2008 and 2017?
Yep. So I worked in beauty, massage. I'm a remedial massage therapist. I also worked in hotels. I was a cook. I'm a cook as well, so I worked as a cook. I worked in my own business doing massage, and I was a school cleaner as well.
And did, in a general sense, that provide some degree of insecurity about your employment?
It did. I was working at some stages 5 jobs in one day, starting at 4 a.m. in the morning and finishing at 11 o'clock at night. And it became doing that 5 days a week, because the school was open 5 days a week, and not making enough to cover my rent and mortgage some weeks. It just didn't make sense.
Now, the nature of the payment that you applied for after you moved to Tasmania was New Start allowance?
That's correct.
And did that have a component of requiring you to actively look for work in order to receive it?
It would have, yes. And I know every time I've been on New Start, I've looked for more jobs than what they've required. I was looking for 200 jobs a day, applying for 200 jobs a day at the point in 2019. So I exceeded the amount of jobs they asked. I wanted to work.
Yes. Now, there came a time, I take it, where in 2017 you were finding it very difficult to survive financially.
Yes.
Despite receipt of the New Start allowance.
Yes.
What steps did you take during that year?
Oh, I think I just budgeted better. I don't have high expenses in food and electricity and those sort of things. I don't go out. I don't, when I'm struggling, I don't have any luxuries. It's bare minimum.
What does the bare minimum look like?
Oh, usually rates, electricity, or sometimes it's not even rates. Sometimes I just let my rates go in arrears because I can't afford to pay them. But generally it's just basic foods, enough to get by. I always had enough food for my daughter, but some weeks I wouldn't eat because it's just wasn't enough money in the bank. Although 2017 wasn't that bad because she was living away from home, it was still would have been, I would expect that it would have been as bad as what it normally was when I was on Centrelink, and the cupboard was basically bare.
You've referred to an understanding that you needed to report your income during the period that you received New Start after you arrived in Tasmania. What was your understanding of whether you had to report your income to Centrelink while you were in South Australia at the employment there?
Well, I was under the understanding that I didn't have to report that income at all because I wasn't on Centrelink while I was working there.
I'd ask that exhibit make sure I've got the right one. Exhibit 1695, CTH.377.5.000.0185_R be brought up. Thank you. Ms. Klieve, this is a letter addressed to you by Centrelink, 7 March 2019. Can you see that on your screen?
I can.
Do you recall receiving this letter at some time in 2019?
I think I saw it at some point. I would have got it when I went back to my house. I wasn't living at my house at the time it was sent to that address. I was living in Burnie. So I do remember, though, when I found out that I had a debt, I contacted Centrelink. So I must have seen that letter to have contacted them.
This, of course, is 2019, a couple of years after you returned to Tasmania.
That's correct.
Why were you living in Burnie?
So I had a job in Burnie and I was doing uni. So I was studying my associate science degree. And because of the job, I needed to live up there. I couldn't drive an hour and a half every day to work and back. Unfortunately, the job ended, but the rental agreement was still in place. So I had to stay in Burnie.
What sort of job was it?
I was canteen coordinator for Lion Drinks Dairy Company in Burnie.
What do you recall about the job market or the employment market after you returned to Tasmania?
Oh, it's always been difficult in Rosebery. It's a mining town. There isn't a lot of work outside of the mines. I have worked in a few of the mines around Tassie at certain times, but I've never gotten a full-time job at the mine in town. I usually work at the caravan park in Rosebery. That was the job I had when my daughter was with me when she was younger. Before I went back to Kangaroo Island, I was working there and working at one of the mines as a lab technician. But I applied for work back as in the lab and couldn't get work. Of course, a lot of years had gone by.
Right. Geographically, where is Rosebery in Tasmania?
It's the west coast, so in between Burnie and Strawn on the west coast in the mountains.
A small town?
Yes, so there was 2,000 people there when I first moved there. I believe it's about 600 or 800 now.
You'd said something about putting some money into a winery.
Yes. So I bought the winery equipment. So I didn't buy a going business. I bought equipment to start my winery. And the lady I bought it off taught me how to make my first batch of wine. She makes fruit wine, so she wanted to sell it to someone who would do the same. So I made the first batch of wine and didn't like the way it tasted. So I went to uni to learn how to make wine and have now, after 5 years, got my wine sorted. My everything's, I've managed to get with the council and find a place that I can actually do the winery finally. And so hopefully by the end of next year, it'll be up and running.
Okay, it wasn't going to make you an income back at this time though, 2019 and earlier?
No, well, I was hoping that I'd be able to get it running back then, but because the councils, it could only be run in an industrial area or rural resource was my understanding, and that's what I kept being told by the councils. Now I've been told it can be done in a commercial building. So it's now been, the rules have changed and I can now have more areas that I can work from.
Mm-hmm. But it wasn't your income earner back then?
No.
Thank you.
This letter dated 7 March 2019 instructs you that Centrelink needs you to check and update your past income information to make sure you receive the right amount of payments from us in the past. If we go over to the second page of that document, we can see past income information there. And there is a reference to the oyster farm, employment at the oyster farm shop. You see that?
Yes.
The amount there is $10,796, so a little over $730 more than the year-to-date figure on the pay advice that you located for the period from 24 October 2016 to 6 November 2016.
That's correct.
Yes. What do you recall about your response once you learned that you had received this letter?
I know when I rang them, I told them I said to them I didn't have a debt. I didn't work at the Oyster Farm shop while I was getting Centrelink. They told me that I needed to supply pay slips to prove that. So that was, there's 2 recordings of me talking to the Centrelink later on, and neither of those conversations are the one that I had with them about this letter, because I remember talking to them about saying that we didn't have a debt, that they had all the information. They could see that I didn't get Centrelink till after I'd left the Oyster Farm shop, that they needed to go back and look at it.
We'll come to those recordings shortly, but they were part of the documents which were provided to you from the documents produced by Centrelink.
That's correct, but I know that I talked to them separate to those 2 conversations, because those 2 conversations are not what I actually said to them in the first conversation I had with them when I found out I had the debt. I know that I talked to them and said I don't have a debt. I was adamant that I didn't have a debt, and they said, we understand you don't have a debt, but you've got to prove that you don't have a debt.
Right. And from what you've given, what you've said about the time that you were employed at the Oyster Farm shop, these dates of employment don't accurately reflect the period of time that you worked there in that financial year. They cover the whole of the financial year.
No, they cover the whole financial year, and that's, I think from memory, I talked to my employer and said to her at some stage about that, and that's how they had to report to the ATO.
That's
that it was for the financial year.
Right. So did you understand what the suggestion was about the information from the ATO being different to the information that you reported? That suggestion on the first page of the letter?
Well, no, I understood that they had a year that they were saying that I'd made the money in, but that they weren't taking into account that I didn't actually work for the whole year. And as I said to them, I could not physically work in South Australia while I'm living in Tasmania. It's an impossibility for me to work in another state while on Centrelink.
And did you have to inform Centrelink where you were living when you applied?
Yes.
In late
So
2000? That's right. That is,
yeah.
in the course of the application process after you returned to Tasmania, you informed Centrelink that you were now living in Tasmania.
That's correct. I wouldn't have got Centrelink if I was living in South Australia because I wasn't eligible. And they actually made me supply. They said I would not be put on Centrelink until I supplied separation certificates or some confirmation of separation from that job.
This is during the application process in late 2016?
That's correct.
To your recollection, what information were you able to provide to Centrelink in that respect?
I thought it was a separation certificate, but I'm not 100% sure whether it was that or they contacted my employer and she verbally gave them the information over the phone or an email. I'm not sure how they got the information, but they put me on Centrelink and they were adamant that they weren't going to put me on Centrelink until they got those documents.
Thank you. If that exhibit could be taken down and the next exhibit ending 0186, exhibit 1696, I should say that's underscore R. Thank you. So the first letter was dated 7 March 2019 and this is dated 26 March 2019. Mm-hmm. Do you recall this letter as receiving this letter?
No, and I would have because it's my daughter's birthday.
All right. If we could go down to the paragraph commence under the box in the middle, if you don't check and update your information, thank you. You can see that you were given a time frame in this letter to check and update your information by 9 April 2019.
Mhm.
And that if you didn't, Centrelink would use the details they already had, including the information from the ATO, and that this meant you might have to pay the money back. What did you understand from the contents of this letter, Ms. Klieve?
Well, I didn't see it at the time, and I wasn't on Centrelink at the time, so I didn't change my address with them or my contact details because I wasn't actually with them, getting payments from them, so I didn't need to. So yeah, I don't remember ever seeing that letter.
That is, at the time of the date of this letter, you weren't living at the address that you were living at when you received Centrelink benefits.
No,
When did you stop receiving them? Do you remember?
I don't remember, but I was working at Line for 3 months and I didn't receive them while I was working there because I was getting full-time hours. So I would say at the least, it would have been before I was working at Line, which when I left Line, I went back onto Centrelink. So that was the date when they started to take the amounts out of my payments.
That was at a later period in time.
Yes, when I left Line, wasn't working there anymore because my contract ended. Then I went back onto Centrelink,
Right.
and that's when they garnished my Centrelink payments for the Robodebt.
You might have said earlier, but when did you have the line job?
That was in 2019. Well, it might have even been in 2018.
Okay, thanks.
If the next paragraph could be called out, please. Thank you. Do you recall at the time at which you ended up seeing this letter, appreciating you didn't receive it at around the date of it?
I thought Ms. Cleavey said she just hadn't seen it at all. Is that right?
No, I've seen it in the correspondence that I got from the lawyers last week. So I read through all of the correspondence from Centrelink then.
Yep.
Thank you. If you could go then to, if we could go to Exhibit 1697, CTH.3775.0001.0187_R. Thank you. This is a further letter dated 11 April 2019. Does this letter fall into the same category as the ones you described earlier where you didn't see them at the time because you weren't living at the address that you were living when you received Centrelink?
I think I might have seen that one on my MyGov.
And do you recall when that was?
Well, if it was sent on that date, it would have been around that date if I had MyGov by then.
There are a couple of things of significance here. You can see in the box in the top right-hand corner, there is an amount due of $2,573.20. You recall seeing that?
Yes.
And if we go down to the paragraph under the heading Why You Owe Money, thank you, you can see there that the reason provided for that amount of the debt is that the correct amount of your earnings was not taken into account in the payments made to you from 26 December 2016 to 24 August 2018. You see that?
Yes.
Now, those dates, 26 December 2016 to 24 August 2018, does that accord with your recollection of when you first started receiving Centrelink and continued to receive it?
Quite possibly, yeah.
You gave evidence earlier that you finished up with the Oyster Farm shop in late October, early November and moved back to Tasmania, and that there was a period of time before you received a payment.
Yes.
All right.
And then I was working casual jobs while I was on Centrelink in before I was at Lion, but they were sporadic. So I was still on Centrelink while I was working those, and I reported all my income from those jobs.
Right, that is, you complied with your obligation.
That's correct.
And is that why you were very confident that you didn't have a debt?
Well, 100% confident I didn't have a debt.
Thank you. If Exhibit 1699 could be brought up, CTH.3775.0001.0252_R. Ms. Klieve, this is a further letter dated 15 April 2019, which refers to finishing checking your past income or having finished checking your past income. The first main paragraph indicates that the Centrelink's records show you did not check and update your information. Was that the case? Did you check and update your information at any point in time prior to 15?
Regarding to what?
Regarding the original letter, which asserted the $10,000.
No, I never gave them any information.
Right. The statement here is that it was the information from the Australian Taxation Office which was used. Did you understand at this point in time how that information was used?
I think I understood that it was an average over the year, which was why it was frustrating, because I said to them, I reported any income I did have. I wasn't working when I received Centrelink in that financial year, so I didn't have to report any income to my knowledge. If I did work, I would have reported it. So I couldn't understand having a debt if I did everything I was supposed to do.
There is a calculation set out in the box below. If that could be called out, thank you. It refers to the amount of employment income you reported, which has a figure of $1,910.68. Do you know where that came from?
I think that was probably from the bakery. I assume that I was working at the bakery that first year that I moved back to Rosebery, and that was only a few hours, a couple of days a week here and there. So that sounds about the right amount for that job.
Okay. And what about the next figure, the amount of employment income reported to us should have been, the $6,977.62?
Yeah, I don't understand that. I don't understand where they got that figure from.
Okay. And the net effect of that calculation, as it was set out there, indicated the debt of $2,573.20, which was the amount in the letter dated 11 April 2019. That is, this appeared to be a further letter which explained how that figure had been arrived at. Was that your understanding?
Yes, but I don't understand how they came to those figures.
I understand. You indicated earlier that money was taken from Centrelink benefits that you later received.
That's correct.
Can you explain that a little bit?
So when I went back onto Centrelink when I was living in Burnie and I was looking for work still, I just got a payment and there was less in it, and I rang them and asked them, I remember ringing them and asking them what was going on, and they said it was part of the Robodebt. And I said, well, I can't live on what I'm getting. And there was nothing that they could do.
Right, that's what you were told?
Yeah.
But you had telephoned Centrelink twice at about the time you received the letters of 11 April and 17 April.
Mm-hmm.
And what, you've had the opportunity to listen to the call recordings
Yes.
in the preparation of your statement, and you've set out in your statement at paragraph 27 and 36 some of the statements that were made in the course of those telephone calls.
Yes.
In the first telephone call at paragraph 27 on 11 April 2019, at subparagraph C, you've heard yourself recently say that you gave Centrelink your separation certificate from there, that is the Oyster Farm shop, and that you were working a long time prior to getting Centrelink benefits. So you recall explaining those things to Centrelink in April at the time that you received these debt letters.
I've actually said that to them more than that, just that phone call. I had more phone calls with them than those 2 phone calls. And I remember saying that I worked at the Oyster Farm shop. I left there, came to Tasmania, went on Centrelink in Tasmania, and I repeated that every time I talked to them.
The second telephone call that you've had the opportunity to listen to is reproduced in part at paragraph 36, and it occurred on the 17th of April 2019. And again, you reiterated that you supplied a termination letter, and that should be on the Centrelink file, effectively.
Yeah. So I don't recall how like whether I could do a separation certificate or how it was done. But if I said it back then, it was probably it was closer to the time. So I obviously did supply a separation certificate.
And it seems that in that phone call on 17 April 2019, the representative told you that the date you started receiving Centrelink was 26 December 2016. That was obviously information that Centrelink had at the time. I see that you're nodding, but...
Yes, sorry, yes. I don't remember most of this. It's quite a long time ago, but if it's a recording, so it's obviously me.
That's right. How did receiving the debt letters and the inability to get any traction on those phone calls with Centrelink affect you?
Oh, it was very stressful. I actually shut down and ignored it for quite a period because it was too much to deal with. And that's usually my coping mechanism, is to just ignore until it escalates and I have to deal with it. But I only started ignoring it after it got to the point where there was nothing else I could do. There was no communicating with Centrelink. They wouldn't listen. They wouldn't do anything about my information I was giving them. They were just adamant that I needed to supply proof. And I know in one of the phone conversations, I actually said I was going to supply proof. That was probably just to get them off the phone, just to get off, get them off my back, or to again, just. And I probably had every intention to get them as well at the time when I said that, and then got off the phone and went, "It's too hard. I can't do it."
Right. If we move then to 2019, you spoke about some of the payments you received at that point in time being taken and applied towards your debt. Did you have financial difficulties again in 2019?
Yes, when I lost the job. So I had no savings. I had a mortgage and I was paying rent at the same time. And my Centrelink payments were only covering my rent and my mortgage. There was no money left over for anything else.
If we go to paragraph 40 of the statement, please, you say there that you saw a letter recently, that is in the preparation for your statement, dated 13 May 2019, which records a debt repayment deduction which was applied from 22 May 2019, totalling $92.55.
Mm-hmm.
You recall money being deducted, and at least that letter is consistent with your recollection.
Yes.
What impact did the reduction of $92.55 have on your financial state in May 2019?
Well, I had to sell everything I could sell just to get a little bit by. I had to go to Salvation Army for the first time ever in my life, and it was quite degrading. They gave me a $50 food voucher and a $20 petrol voucher and told me that was all they could give me because I wasn't actually in dire straits. I still owned my home. So they couldn't help me any more than that. So I sold bits and pieces and tried to get some massage work, but couldn't even get that.
And the
I
bits
then
that-
sold,
Yes.
I then got a loan from my parents because that was my last option. I had to ring them and tell them what was going on. And I was quite proud and didn't want to do that. And I remember having a tearful conversation with my parents about it. And they put money in my account, which got me through until I started my next job.
You said you sold bits and pieces. That included your car.
Yes. Yes, which I was quite upset about at the time. I spent $8,000 buying the car, spent $4,000 on repairs to the car. It was a van that I used quite a lot to transport equipment that I bought for the winery, and it got me to Tassie. And I had no option but to sell it, and I sold it for, I think it was either $2,000 or $2,500. So I had a really big loss, but I had no other option, and I had another car, so I had to sell one of my cars. It was the only way I could see to get out of the situation that I was in.
We can go down to paragraph 45. You've summarised there a letter that was addressed to you, dated 7 November 2019 from Centrelink, and the amount at that point in time was $1,743.63. That's the debt that was left at that point, after
Yes.
various amounts have been taken from your Centrelink payments.
So when I got the job, I finally got a job at Savage River Mine as a utility worker, and I then ignored everything to do with the debt because they had no way of getting the debt paid from me at that stage. And I was so angry and so traumatised by the whole ordeal, I just didn't want to have to deal with it anymore. So I didn't even contact them. I just got cut off Centrelink.
And if we go to paragraph 46, you became aware in 2020 from social media that a class action had commenced.
That's correct.
And ultimately you received, in fact, a letter from Centrelink in respect of the class action. Before we come to that letter, we can see in paragraph 47 that by 5th of August 2020, the money that had been taken from your Centrelink payments in 2019 had been repaid into your bank account.
Yes.
Now, the total at that point was $829.57. Were you working at the time that money was repaid to you?
I believe I was.
Would you agree that the money taken from your Centrelink payments in 2019 was during a period when you actually needed that money?
The repayments, no. I think I was working on the boat at Gordon River at that time, working almost full-time hours. So I'd actually started to save some money again.
I don't know if you heard Mr Gregory correctly there, Ms Klieve. The question was when the money was actually being taken out when you were on Centrelink.
Oh, when it was taken out, I was, yeah, when it was taken out, I needed it. Desperately needed the money when they were taking it out.
What about when you had the money refunded to you in 5 August 2020? Was that an equal state of desperation financially?
No, and that's what I was just saying. I think I was pretty sure I was working then, and I had savings. I was working full-time hours.
describe how you felt following the receipt of that letter and the repayment of funds in paragraph 48. But overall, at paragraph 49, you talk about the impact that your interaction with the Robodebt scheme had on you. You say it made you feel like a second-class citizen. What do you mean there?
There's a stigma attached to people on Centrelink, and I never felt that way because I always worked while I was on Centrelink. I only ever went on Centrelink because I desperately had to. It wasn't a choice, it was a need. And so I never felt like I was second class when I was on Centrelink because I'd worked since I was 13 and I'd worked 3 jobs at a time. I'd always, done my bit and paid huge amounts of tax. And I thought, well, I've paid for my Centrelink. I've contributed to the tax that pays for Centrelink. So I didn't feel guilty about getting Centrelink when I desperately needed it. With this, it made me feel like I was a criminal. And it made me feel like what I assume a lot of people on Centrelink feel like most of their life.
Where has that left you in terms of your view about Centrelink as an option in the future?
I never want to deal with Centrelink ever again. To the point where doing this whole system, I realised last week that I was doing things to probably be self-destructive, but because of my fear of going on Centrelink again. I was looking for extra jobs, looking for, more security, and it's almost put me back into that mindset of, it's that everything is not stable. And I didn't have that mindset before Robodebt. Even when I lost the job, I always felt like I had some sort of stability with being able to get at least enough to pay my bills at the minimum with Centrelink and be able to work at the same time. So I wasn't ever just on I don't think anyone can live on Centrelink alone. I think you almost need to work while you're on Centrelink to be able to cope with finances. Yeah, that's pretty much it.
Thank you very much for your time, Ms. Klieve. I have no further questions.
Thanks, Ms. Klieve. Have we got cross-examination, Mr. Glover?
No, thank you, Commissioner.
All right. That's all. Thanks a lot for your time, Ms. Klieve. I hope that just hasn't been too upsetting for you, remembering it. But it's been
I
really
hope that
helpful.
something good will come out of all of this, and it'll help not happen again to anyone else, because it shouldn't happen.
Okay, thanks. It's been very good of you to spend the time with us. All right, we'll adjourn. Thanks.
All rise. The Commission stands adjourned until 10 a.m. tomorrow morning.